I just pressed the let's go live button, which means we got to wait for the stream to fire up all across the fruited plain of the internet. Before we go ahead and get started, let's get the tubes connected on the day and get ready to rock and roll. Let's make sure we're connected on the YouTubes, on the Rumbles, on the locals, and everywhere else before we start popping off here. It looks like things are well, so that means we can go ahead and get started. And so let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia, and today we're talking about the Trump trials. We've got a motion for a mistrial that has come out in the New York City case. This case, of course, brought by Leticia James, and we're going to get into it. It is about 30 pages or so. We can see here it is 30 pages exactly, and so we're going to go through that in full detail because it is a memo in support of a mistrial. We know that Alina Abbe and the Trump defense has been saying this has been coming for some time, and I'm looking forward to going through it here today with you. A question has been about Alina. People haven't seen her the last couple days, and people are wondering where she might be. And so we'll have to see what that story says. We also have a short day of trial. KlasfeldReports was there. InnerCityPress was reporting very briefly, and there just wasn't a lot going on. We remember that yesterday we were picking back up the direct examination with Jason Flemings, and Jason Flemings is an accountant who was there testifying. And so they finished with him today, some brief cross-examination, and there wasn't much to report on it. But we are going to go through it just to see what happened. The big story, of course, is the mistrial motion out of New York. Then we're going to turn our attention to Hunter. Oh my goodness. What happened here? People are saying, okay. Says here, Hunter is also now subpoenaing Donald Trump. And this is a curious thing. So this is something we're going to go through. They filed a request in the Delaware court for a subpoena. They want the judge to grant him permission to go get some documents from Trump and from Bill Barr as well, Jeffrey Rosen and some others. And so we'll read through this thing. It's a 16-pager, pretty quick, but we'll also look at the subpoena that went over to Trump, and it should be fun. So we'll see what that looks like. And I'm actually kind of interested in this. I mean, it's like, hey, you give Donald Trump an opportunity to show up with everything he knows about Hunter. Okay, man, you want to go down that road? You want to open the door, as you say in the law? All right, well, Trump will say, well, can I have some of my boxes back that you guys raided from me? Your dad raided from me? I'll give you everything you want. You already know. So then we're also going to see what's happening out in Georgia, because there was a pretty big hearing today. Of course, we were talking earlier in the week about the leaked videos, Fani's leaky office, and there was Jenna Ellis and Sidney Powell who had their plea deal proffers published, and we know who published it now. In fact, it was this defense attorney. His name is Jonathan Miller, and he kind of like begrudgingly made the admission in court today. He said, it was me, but I did it because I should do it, because what's happening in Georgia is a total scam. And so we're going to go through it today. We'll listen to what he said. It kind of was kind of like a tense moment in court. You're like, uh-oh, how's this judge going to react? Because we didn't know if Judge McAfee was going to think this was like, a big no-no. How dare you leak this discovery stuff? Even though there was no protective order, even though there was no real reason why he couldn't share it, it was curious to see how the judge reacted. And so, of course, we'll save that. This is what the hearing looked like. It was quite long. I have it queued up. We'll try to fast forward through some of the boring stuff. There was a lot of activity. A lot of lawyers were coming in here. Obviously, it's a RICO case. There's 19 co-defendants, and others have taken plea deals, but there were still, there were people still there who were representing the other co-defendants. And so we'll go through it and see exactly what is happening out of Georgia, as well as some of the Hunter stuff. And so we've just got a lot to attend to today, and we're grateful that you are here and with us. And so, of course, before we get into that, we want to talk about a new sponsor here on our channel, which is called The Wellness Company. And of course, we can find them over at twc.health/Robert. But they have, something very interesting I want to share with you, because you may know, and of course, I learned a little bit about this last, a couple of years ago, right in the middle of the pandemic, as it were, but over 90%, They're almost over 90% of pharmaceuticals in the United States are produced outside of the United States. And so my brother Joey was in the hospital. My mom was there at his side during COVID. And it was a wild situation here. I was literally calling different doctors and different pharmacies to try to track down some stuff to bring to my mother while she was in the hospital. I mean, it was a wild, wild scene. And I don't want to go back there at all. But the point is, what happens when the next crisis strikes? What happens when this happens again? If it does, countries clamp down on exports. Everybody starts stockpiling things, and the prices on drugs rise. Pharmaceutical shelves in America are empty. People are scrambling, and that's where the wellness company's medical emergency kit can help. Now, this kit that you can get at this address here, it holds 8 life-saving medications that every American should have on hand. We've got antibiotics, antivirals, antiparasitics. This kit contains medication that you need like amoxicillin, ivermectin, a Z-Pak. It's got a 22-page guidebook with complete instructions on safe usage, and it covers everything from tick bites to COVID, extreme bioterror events. Every scenario is covered, so it's just a smart thing to do. Now, these prescription kits are in huge demand right now, so head on over to twc.health/Robert. Grab yours. And of course, there's code Robert there, and that's going to save you 10% at checkout. So twc.health/Robert. If you've got Tylenol, you're going to want to have this kit on hand. Be safe, my friends. Be prepared and stay well. And by the way, these kits are only available in the United States. So twc.health/Robert is the place where you can go. We appreciate the sponsors of today's stream. We also have our website, robertgovea.com, which is where you can go and check out our daily show reports. You can also sign up for our daily newsletter. You can learn about the mind map, how to use this very tool, and you can access all of the PDFs. Everything we're about to go through, you can access at robertgovea.com. And then members, stick around for our members only after party, which is, oh my gosh, locals. Oh gosh, which is watchingthewatchers.locals.com. In fact, you want to see what's going on over on Locals right now. Speaking of Locals, oh gosh. All right. So this is what happens right in the middle of my promo for Locals. Here's what they drop over here. You ready? Oh, isn't that special? What a nice, happy couple. Couple of sharp lawyers there. One of them's definitely a lot smarter and a lot better looking too. So we know who that is. And so that's what's happening over on Locals, and absolutely hysterical. So, okay, so we'll follow up on that after the stream. All right, so watchingthewatchers.locals.com is where you can join us for some of that fun stuff. And matrimony, it sounds like. So come check it out, watchingthewatchers.locals.com. Members, stick around for the after party. We will have some fun after the show. And YouTube friends, if you're a member on YouTube, you get all the same stuff, except the after party. You're going to want to grab the private Telegram group link so you can join us on that after party fun. All right. And so let's get into it on the day. We've got some business to attend to. And so let's get started. Trump and his defense demand a mistrial in the New York City civil fraud trial brought by Leticia James. We're going to go through the motion. It's 30 pages long, filed by Trump's defense, and so it should be good. We're also asking ourselves, where's Alina? Where's she been? Story says she's been missing from trial. We're going to see if we have any idea where she might be or what she's up to. And then we'll take a look at another day of trial. This one is with the finishing of the direct exam of Jason Flemings, an accountant who does some forensic accounting, and the brief cross-examination in trial that occurred. So we'll start off with how things unfolded in the morning with a new motion for a mistrial. We've been waiting for this one. We've been following Judge Engoron and Leticia and all the shenanigans out of this courtroom for quite some time. I'm waiting for this one, right? And the media has been asking about this too. They've been wondering, asking Alina and the rest of the defense, when is this coming? Are you going to, ask for some sort of a mistrial? And they say, yeah, hang on. Here it is. And so here's what it says. Filed in the case of New York brought by Leticia against Trump, Weisselberg, Trump Jr., everybody, blah, blah, blah. This is Trump's memo of law in support of a motion for a mistrial. We've got a nice table of contents. We'll hit the highlights here today. We'll fast forward through the table of authorities and the notice of the parties. And what we'll see here is the preliminary statement filed by Trump. They open. The Constitution guarantees defendants a fair and impartial trial. Here, in an unprecedented case commanding worldwide interest and attention, it is imperative that nothing compromise that guarantee and thereby undermine public confidence in our legal system. And backing up briefly, this motion is filed in the same court of Engoron, just to be clear. So it's Engoron who is getting this motion, right? So Engoron is the guy who's been presiding over this botched clown show of a trial, and they're submitting this to him saying, hey, judge, you're doing a pretty terrible job. Now, while counsel, Trump's defense, are subject to a gag order from Engoron, apparently imposed to impede the issues herein presented from becoming public. You don't want us talking about this. Alina's been trying to hit the media, and they say, can you tell us what's happening with the love notes between Greenfield and the judge? He's like, I can't talk about it. The judge gagged me. He doesn't want me talking about his GF. So they say it is a fundamental precept of American jurisprudence that sunlight is the best disinfectant, which is why we have a spotlight here for when they try to cower in the dark of night. Indeed, the assumption that respect for the judiciary can be won by shielding judges from published criticism wrongly appraises the character of the American public opinion, and an enforced silence, however limited, solely in the name of preserving the dignity of the bench would probably engender resentment. Yeah, it does. Suspicion and contempt, much more than it would enhance respect. Supreme Court said that in 1941. Pretty smart line there. Yeah, the judge is saying, you're gagged because you can't talk about my Greenfield, my GF, in my courtroom, and you can't criticize how we're handling this, and gag, right? And they say that gag is harmful to their case, and it's going to jeopardize and undermine the legitimacy of the institution. But when they gag you, every one of us turns around and just says, oh, that's perfect, right? Typical. It's exactly what tyrants do. They try to stop you from seeing their tyranny. And we take it and amplify it and magnify it, right? This is also something called the Streisand effect. When you try on the internet to silence something, everybody goes, oh, that's curious. Why are you trying to hide that from us? We don't like you hiding things from us. So how about we re-X that into oblivion? And that's what ends up happening. So the same thing here, except now this involves politics. And of course, the gag is partisan and corrupt. And so we now have questions about why they're trying to interfere with an election in addition to prosecuting, and in this case, stripping one of their political opponents of $250 million and wrecking his businesses. So while the court has restricted public criticism of itself on the issues herein presented in a series of unconstitutional gag orders, and I know we're a lot of gagging going on in the Trump cases, but this is New York City, not Chutkan, which is currently on appeal. But to be clear, Chutkan's gag order and this gag order, they feed off one another, right? They say, see, Trump's doing it in that court, so we got to do it here. And then they, vice versa, they flip it around. In this case, these gag orders were entered sua sponte, which means on the initiative of the court. They just decided to do it on their own. The Supreme Court instructs our Supreme Court that the operations of the courts and the judicial conducts of judges are matters of utmost public concerns. So if you are sending love notes to your GF in court, Judge Engoron, we should be able to talk about that, as should the judges. Now they say, moreover, Judge Engoron, there can be no doubt of the public perception of bias in this case. Even commentators who are politically opposed to President Trump have noted the biased nature of these proceedings and the astonishing departures from the ordinary standards of impartiality. See, for example, Andrew McCarthy. He wrote about it at the National Review. He said, the case against the former president lacks victims, and he calls her Tish too. My man. So he says, so Tish James, because that's her Twitter handle, man. It's not just me. That's what she went by. So Tish James and Arthur Engoron. Now, at some point, I think McCarthy will join us and he'll insert the Areola moniker here, his middle name, Areola. So Arthur Ari Engoron is how we'll call him here, are inventing some. Engoron, Areola, keeps cutting Trump and his lawyers off by insisting that he has already decided Trump, A, committed fraud, right, just decided it, and B, overvalued his assets, just made that decision, and C, cannot be insulated by the disclaimer that is in the documents. And advising his counterparties, that disclaimer was, hey, what I'm showing you, it's not accurate. Like, it's my interpretation, but you should do your own due diligence. Judge says, well, that's still fraudulent. But no, you said, but I disclaimed any fraudulent intent. If I was committing fraud, I wouldn't have put the disclaimer in there saying you should do your own due diligence. I would just say this is accurate and just do it, right? The judge, well, now that really wrecks my case, though. I have to find you fraud, obviously. So the appearance of bias, as they say, threatens both Trump's rights and the integrity of the judiciary as an institution. I mean, to try to communicate the damage that they have done to the DOJ and to the concept of the law with these multiple different prosecutions, I think is probably irreparable, to be honest with you. And it's a sad thing to say and to admit. Like the 4 different criminal prosecutions, plus what they've been able to do in New York with the civil prosecutions with E. Jean Carroll, Miss Bergdorf, and then the other civil fraud case that we're talking about here, it is wrecking, I think, the public's perception of the judiciary. Then you add in January 6th, then you add in the FBI and all of the weaponized, domestic incursions that they're investigating, plus all the censorship. I mean, it is them doing the damage. It's not Trump and his Truth Social account, all right? So they and their gag orders, again, multiply and amplify all the criticisms. So as developed herein, Trump's defense says, in this case, the evidence of apparent and actual bias is intangible and it's overwhelming. Such evidence, coupled with an unprecedented departure from standard judicial procedure, has tainted these proceedings and a mistrial is warranted. Oh, we got the GF coming up. Specifically, they say the court's own conduct, Judge Engoron, coupled with the principal law clerk, the GF, Allison Greenfield, which is why we call her the judge's GF, her unprecedented role in the trial and the extensive public partisan activities would cause even a casual observer to question the court's partiality. Thus, only a grant of mistrial can salvage what is left of the rule of law. Maybe. I'm not sure. I think, it's pretty much damaged. Now, they say on argument on defendant's motion for a directed verdict, they give us an example that they referenced in footnote 1. They're saying, hey, Judge, you got some pretty serious bias here, footnote 1. Well, specifically, we were asking for a directed verdict, which means, in other words, the government presented all their evidence, and even if you believed all their evidence and took it all as true, there's still not enough there to convict or to find Trump liable for the fraud and the disgorgement. So they made the motion for a directed verdict. Judge, we can't lose, okay? They presented no evidence. Specifically, they were making the argument about what weight should be accorded to Trump's testimony. And the court asked the following question. The court said, Engoron says, can I bring up something not in the record, but a matter of public knowledge? Says Engoron, I guess. I think the perfect call with Zelensky about the military aid, there might have been code rather than straightforward talk. What? The court asked the following question. Can I bring up something that's not in the record, but a matter of public knowledge, the judge says? I think the perfect call with Zelensky that Trump always rails about on, Fox News, about military aid, there might have been code rather than straightforward talk. People are going, what the heck are you talking about, man? He's already impeached over all this crap. We're here in trial with Tish for business deals. So this is an affirmation of Clifford Robert. So they probably got somebody who, is signing off that I heard this stuff. They say, Your Honor, such reference to a purely political trope demonstrates the court cannot separate his, Engoron's, and his principal law clerk, his GF, their political bias from the obligation to be fair and impartial. They say, Your Honor, this court has contravened the code of judicial conduct, and you've created the appearance of impropriety through publicly commenting on a proceeding before you. This court, in its capacity, Your Honor, as the Wheatley School alumnus, which we read through the letters here, that was the Areola show, which was a wild scene here. But we had to analyze a judge's nipples on this channel. Because he put it in his newsletter, not because I wanted to. It's part of the court record here. This court, in his capacity, this judge, as his Wheatley School alumnus, as his newsletter author, has publicly posted links in the newsletter that he maintains to articles disparaging the parties in the council. We saw that. That was in addition to the bonus torso photo that he also weirdly exhibited, not voyeured, he exhibited. We learned about our degenerate terms last show. Exhibited in his newsletter. But in addition to the bonus torso photos and his areolas, we also saw him put links in there. He was, he's like proud of his work. The judge did this. The judge denied Trump. The judge did this. He says here he was bashing Eric Trump, President Trump, Miss Abbe, Cushman, and Wakefield, and covering his own decisions in derogation of the code. The code says a judge shall not make any public comment about a pending or impending proceeding in any court within the United States or its territories. The judge is shoving it in his newsletters next to his nipple photos. Here, look at this. Ah! Like, no. In an October 2nd, 2020 newsletter, which we covered here, and that's a wild show. You should go check that one out for sure. This court included links to articles about Eric Trump being compelled to testify in a subsection called Art Engoron Articles About Decisions, right? And we covered that here. In December 28th, another newsletter, the court also linked articles to the judge's decision about the Trump Organization. He linked to Bloomberg, WAPO, CNN. In February, this court also included links to articles that he characterized as a humorous, irreverent take. He's just, no, I'm just having fun with this. In November 2021, the newsletter, the court entitled 1967 Man in the News, that's Judge Engoron, he's talking about himself, look how great I am. He linked 5 articles, again, from Washington Post, from CNN, and from Bloomberg about his order in the special proceeding that compelled Trump to turn over the documents. It's like his Facebook account, right? He's like, look what I'm doing. I'm compelling Trump to do this. Look at my chest. In March 14th newsletter, 2022, so we just keep coming closer, the court likewise in the graduate news section posted links to the New York Times, Washington Post, and Politico regarding his decision in the special proceeding to order the defendant to testify. I'm going to order Trump. Look what I'm doing. May did the same thing, posted in New York Times. He's holding Trump in contempt. Man in the News. The court again linked to an NPR article saying that Trump lost his appeal. It's the court. This is Engoron, right? This is the judge. The court is a nice, euphemism for this guy. It is Engoron who is thrilled about this. He's doing cartwheels with Tish. Anyways, the court similarly linked an article from Business Insider and 2 days later then held Cushman and Wakefield in contempt. And finally, on September 11th, just 10 days before this lawsuit was filed, the court posted a link to the Above the Law article criticizing Miss Abbe in September 11, 2022. So this judge is now presiding. So they say, obviously, this judge is biased as can be. He's been spamming his anti-Trump lawfare, his little attacks to his captive audience from Wheatley. Now, the court, they say, also has improper judging, and this is where we're going to see from the Greenfield. They say, Your Honor, Engoron, you have impermissibly exceeded your discretion. He says, it's just my law clerk. We have a very, I forget what language he used, a very curious, commingled relationship, and that's normal. And we're like, well, I don't know what that means there for you guys. But they say you've exceeded your discretion in granting his principal law clerk, quote, unprecedented status and input into these proceedings and restricted the speech of anyone who even seeks to comment on this status. They were saying, hey, she's passing love notes. And that's inappropriate. And they say, don't you talk about my love notes. If she wants to massage my neck, she can massage my neck, and I don't want you talking about it. Now, input or any perceived partisan bias, not allowed to talk about it. This court has, during the special proceeding, all pretrial proceedings, and since this trial began, allowed his principal law clerk to preside on the bench with him to his right-hand side, literally sitting up there next to him. It is a co-judge, okay, not at a clerk level. This arrangement is depicted below in the photographs published by Getty Images and the Associated Press. They're literally like at the same level with laptops. She might be playing footsie with him. You can't tell. Look how close they are. I was only joking about the love notes, but it might be, you could do a little old, hand on the knee maneuver or something like that. And I don't want to get carried away with this, but they're awfully close. Now, you never see this in actual practice. Like they have their laptops together. This is the court actual the court computer that's built there. She's got her laptop here with all the notes, and she's within touching distance of this judge. Wild. And they're just communicating. They are co-presiding over this case. And that is very, very strange. Okay, so they're calling that out pretty aggressively here. And they say, here's another photo. There they are. The judge and his green field. Oh, man, she does not look happy, probably looking at Trump right there. We're going to learn more about her, no doubt about it. But is this what you normally see when you watch different court proceedings? Do you see the judge and like is this? Let me ask you this: is this a court of appeals, for example? Like think about that. The Supreme Court, do they all sit on the level? Right? They all sit on the level. This is by design, by the way. Like the judge is above everybody else for a reason. Right? They don't put the judge below everybody else. That's why the judge is up there, and the clerks are down. The witness is down. Everybody else is down, and the public is behind the bar. So all of this is by design, right? This is elevating this judge. She's not a court of appeals, a co-judge, another judge on the bench. No, not at all. How do we know that she is not acting as the judge? That's the point. This is Arthur Engoron. This is Allison Greenfield, sits alongside him right up there on the bench. Now they say, as these photographs reflect Engoron, weirdo, the principal law clerk is given unprecedented and inappropriate latitude. The court, before the court, they say, rules on most issues. The court either pauses to consult with her on the bench or receives from her contemporaneous written notes. Now, while a justice of the court, no doubt, has ample discretion to consult with his or her law secretaries, this unprecedented arrangement exceeds the outer limits of this discretion. They say, Judge, at a minimum, the appearance of, quote, co-judging is manifest, and the public and litigants may conclude fairly that an unelected staff member has, as is evident from the above images, a literal direct role in presiding over the trial. This creates the appearance of impropriety contrary to the letter and the spirit of the rules of the judicial canons, saying, quote, a judge shall avoid impropriety and the appearance of impropriety in all of the judge's activities, which would include love notes with your Greenfield. Only a judge, not an unelected staff member, may exercise judicial authority under the New York Constitution, or its unauthorized practice of judging, right? And the people of New York declined to elect the principal law clerk when she ran for office. Oh, she's a wannabe judge. Oh my gosh, it all comes into play. She ran for office, and now she's just playing judge. Oh, isn't that fun? Now you know the personality. Now you know this person. Oh, great. Well, you didn't. I'm his principal law clerk, though. Well, yeah, but you're not a judge. But I'm his principal law clerk. Okay, Allison, relax. So she, therefore, has no constitutional authority to act as a co-judge. And the impropriety of her participation is further magnified by the fact that she has violated a separate canon of ethics by making partisan political contribution in excess of strict limits, including to organizations actively supporting Attorney General James and opposing President Trump. And you can tell that just by her face. Look at this face. Okay, look at that. Like you can just see she hates Trump and loves Tish. Oh, gosh. And so, of course she did. She made all those donations, ran for office as a law clerk. Good thing she didn't get elected because apparently she doesn't understand the ethical rules that you're not supposed to do that stuff. Regardless, the Trump defense says the impact of this untoward level of participation by the principal law clerk, Engoron's GF, cannot be overstated. Indeed, during a candidate forum in connection with her erstwhile campaign for the Manhattan Civil Court where she lost, the principal law clerk herself framed her role as a co-equal, describing her participation in a high-profile real estate as follows. She says, we were incredibly active in that case, and we tried to stop the two towers. And during that same forum, she described her judicial philosophy. as driven not by the facts and the law, but by political considerations. She says, one thing that I think is incredibly important to consider is what would the people who elected me want me to do? You hear that? Gosh, she didn't get to become a judge, but now she's role-playing one. And is there any precedent that would allow me to achieve that outcome? Okay, so she's an activist. That doesn't follow the law. How can I manipulate to get the outcome that I want? So this statement is fully contrary to the rules of judicial conduct, which says that a judge must be faithful to the law, derp, and must not be persuaded by partisan interests. Saying a judge shall be faithful to the law, this is part of the code for judges, and maintain professional competence in it. A judge shall not be swayed by partisan interests, public clamor, or fear of criticism. But of course, that's what all these people are doing. Now, we talk about the gag orders. They say, also, as part of her campaign, the judge's GF, the principal law clerk, created and maintained a website. It was called Greenfield for Civil Court. She started a website and an Instagram and a Twitter account. And in February 2022, while the special proceeding against many of the same defendants in this case was ongoing, she posted on her Greenfield for Civil Court Instagram endorsements from the Village Independent Democrats and the Grandstand Democrats. On February 26, she made a post purporting to withdraw from the Democratic primary, but advised followers to keep an eye on this space. Now, thereafter, she continued to post on the Greenfield account. For example, on April 30th, she posted a picture with Senator Chuck Schumer, which was ultimately reposted by the Judicial Protest Twitter account and subsequently posted by President Trump. In the photo that she took with Chuck Schumer, which is why Trump, I think, said she was Chuck Schumer's girlfriend or something like that, she put the photo online. She said, "So thrilled to attend the Chelsea Reform Democratic Club Founders Brunch today, honoring incredible and fearless lifelong public servants like Senator Schumer and Rep. Maloney. Thank you, CRDC NYC, for a fantastic event." They say, Your Honor, it looks like the Greenfield for Civil Court account is still active, but was made private in the days leading up to the trial. Now, I just want to pause on this. This is Judge Engoron, okay? And he must be reading this just exploding, okay? I can't even imagine how mad he is, because he was screaming at them in court. Don't do it, Chris! Don't do it! When Chris was saying, I'm going to file a response. Don't do it! And now he's airing out Greenfield's Instagram account, and she's like dancing around with Chuck Schumer. He's like, wait, hey, Allison, I thought that what? Schumer? Chuck Schumer? I know Chuck. Really? I had no idea. I thought we were going to be forever. But, so he's having a meltdown. Not only is Christopher Keese airing out all this dirty laundry of this relationship, but now Judge Areola is having to deal with Senator Schumer, who's a senator. He's kind of a little more powerful than this judge. Man, hearts are breaking there. So following a repost of the Schumer picture by Trump in what may reasonably be interpreted as an effort to shield the law clerk's, quote, co-judging and her partisan political activity from public scrutiny, the court, sua sponte, on their own, entered an unconstitutional gag order prohibiting all parties from posting, emailing, or speaking publicly about any members of his staff, including his Greenfield. Now, she posted it on her account, right? This was all public. This was on her civil court Greenfield 4 account. And Trump just retweeted it. So it's not anything private, okay? She was probably got a lot more views. So nonetheless, the principal law clerk, the GF, her unprecedented role in the proceedings after the unconstitutional gag continued to be the subject of significant on-the-record colloquy, right? They were battling over the stuff in court. Your Honor, a lot of conversation about it. For example, on October 25th, 2023, Mr. Keese, the defense lawyer for Trump, he described the, quote, considerable tension caused by her position on the bench. Your Honor, you're making us very uncomfortable. Can she not reach over there under the desk? Please, man. saying it's considerable tension is being caused by her position on the bench and indicated that it is, quote, unusual for a principal law clerk, GF, to sit on the bench. Ugh. Now, Mr. Robert described his experience. This is Robert who wrote this affidavit or this affirmation. He says, Mr. Robert described his experience in New York State, such as he had never seen a situation where you're literally trying the case to two judges with notes constantly being passed. Okay, so this guy that they're submitting as evidence, like, Your Honor, it's not just the lawyer saying it. Okay, we've got evidence on the record. This guy wrote a whole document about it. You're literally trying the case to two judges and notes are constantly being passed, among other things. So where it would, quote, appear the court is in consultation with the principal law clerk with each ruling. She's just, the wannabe judge is like actually getting to role play judge. She's LARPing right now. So Mr. Robert, he further described that this court would, quote, appear to be leaning in one direction, and then he's going to receive a note, or there'll be an eye gesture or a roll of the face, and something changes, and it is of significant concern to the defense. The judge is like, yeah, that's a good point. What do you think, honey? Overruled. Overruled. Yeah, that's what I meant to say, overruled. See you tonight. So Miss Abbe says, Your Honor, it is incredibly distracting when there are eye rolls and constant whispering at the bench when I'm trying to cross-examine a witness. Can you two get a room later? I'm in the middle of an exam. The following day, counsel added, they said, Your Honor, I think that Trump has a legitimate basis to raise these arguments because he is seeing, as he's told me on a regular basis, head nods. Trump can see it. Eye rolls. He's seeing notes being passed. He's seeing head shaking, comments on arguments that I'm making. Trump is saying it. I have to bring it up. And so when we brought this up, the court notably had no rejoinder to that statement. Like, what do you want me to do about this, Judge? My client is sitting here and he can see you say it. He can see it. Now, the following week, the defense requested further clarification. They said, look, Judge, we need to continue to make a record. We're going to make a record every time that you accept a note from your Greenfield or other conduct that we think evinces bias. We're going to make a note of it. We also think that there are news reports that have come up that show there are violations of ethical rules by this court and your law clerk. Like, the news knows it too. And the lawyers also noted that since comments were made on the record about the constant note passing, the closed circuit camera angle had been changed. Oh my gosh. These people are just as devious as it gets. They will tell you that they want this all to be public, won't they? But first of all, it's not, okay? Now, there's a closed circuit camera that people can watch in the courtroom, right, where the people in the media can be commenting about this stuff. But they hid it from them too. They've gagged people in the courtroom and they're changing the camera angles so you can't see the love notes or whatever, okay? Whatever they're doing there, which I don't know. They're on the same level. There's a big bench there, right? You can't see. The bench is up there. You don't know. Wow. So they say counsel also noted that since we commented on this, the closed circuit camera angle had been changed, which made it more difficult for the public to see any note passing. The court admitted to knowing the camera angle had been changed, but feigned ignorance as the reason. Your Honor, why was the camera moved? Now, as for the camera being moved, this person said, I was vaguely aware that Rob, the tech person, was switching the angle of the camera. Never occurred to me that it could have anything to do with what we're discussing today or why it was. That's what Engoron says. No, I don't know. Bad angle, bad lighting. That's why we changed it. These people. Now, as further colloquies, further conversation in the court, this court concluded, Judge Engoron, that he would, quote, consult with his principal law clerk for the trial. In fact, every week or every day, and to consider the record preserved and closed as the court has, quote, an unfettered, absolute right to consult with my law clerk anytime, any place about any matter, even love notes and foot massages. Now, ultimately, the court issued a second gag order, prohibited even the lawyers, okay, so not just Trump, but even the lawyers, from making any public statements in or out of court that refer to any confidential communications in any form between me and my staff. That's the judge, right? Like pounding the table, freaking out, which is why I'm saying that as this is all being publicly read and as we're reading it right here, and as I hope you share this, that more and more people know about all of this stuff, because the judge, oh my gosh, he must be losing his mind right now. He said, don't do it, Chris. They did it. Now, the following day, lawyers came back. We sought clarification asking. They said, Your Honor, we want to move for a mistrial, and we have a question. Are you going to hold us in violation of your gag order? And the court said to Chris, he says, I'm going to file a motion for a mistrial, and I'm going to challenge your gag order and all your weird love notes with your Greenfield. I'm looking at you too, Allison. You're coming up in this note too. We're going to look at your Instagram at 2. And the court responded using counsel's given name rather than his surname, right? He's calling him Mr. Keese this whole time. The judge screamed at him, don't file that motion, Chris. Don't file that motion, Chris. Rah. And man, when my mom used to call me Robert, like from across the house, oh man, it was big trouble. Robert! Oh gosh, she found the thing. Yeah, oh gosh. So this is pretty serious. Now, this is not, in a household with a mother scolding her son. Like, okay, that's fine. But this is a court. This judge is not supposed to be biased like this. And he's getting very reactionary here. Then, after yet another, quote, confidential communication, she passes him another love note. She's like, hey, don't call him Chris. You're kind of losing your cool here. I'll relax. The court then allowed the defendants to make a motion. She's like, actually, you have to let them do something. She's like, not an idiot. She's like, they got to do something. Otherwise, this thing's going to blow up. So she says, okay, the court says, okay, you can make a motion, which is the one we're reading now, without violating the gag order, but said that any motion would have to be in writing, which is perfect. It's the one we're reading today. Trump's defense says, now imposing limits on a party or a lawyer's ability to address in court the issues in court is simply not justifiable, and it's certainly not consistent with the avoidance of the appearance of impartiality. It's, in fact, the opposite. They say the right to a fair trial is sacrosanct. Thus, anything that at all infringes, potentially or otherwise, on such a right must and should be questioned in open and in a public forum, and we're doing that now. They say the principal's law clerks, the GF's partisan activities, all those donos and such, those are directly imputed to the court. That's you, Engoron. Saying the appearance of impropriety created by Greenfield and her co-judging and this court's repeated attempts to silence us is further exacerbated. So if that's not enough, if not, the love notes and the massages and all the things, plus the gags, several of those, we can add in her partisanship under the law. First, this court and her violated this court and the code of the judicial code by allowing Greenfield to contribute to Democrat causes in excess of the permitted amounts and to engage in impermissible partisan activity. The law says you can't do it. In fact, it says, a judge shall prohibit, Engoron, members of the judge's staff, which would include a principal law clerk, even if she is your GF, from contributing directly or indirectly money or other valuable consideration in amounts exceeding $500 in the aggregate during any calendar year. That comes from the New York Code, Section 105C2. Now, as set forth below, during the pendency of the special proceeding that led up to this case, and then after this case was already filed, the judge's Greenfield contributed over $3,000 to Democrat candidates and organizations in 2022, and over $900 this year alone, which is a lot of money, right? I don't know what everybody else's political spending is, but that's a lot. That's like times are tight right now. You got extra $3,000 to just drop at Democrats? Like, you must be pretty serious. I think most people will donate $20, $50, $100 here, and I really support this guy. $100 maybe. But like, she's maxing out. That's a lot of money. So she's pretty, into it, I would say. The official New York State website publicly chronicles these contributions. Well, let's take a look at them, shall we? Oh, it's a lot of them. Oh, the judge does not like that. Oh, it keeps going. Oh, man. So the judge didn't want any of these love notes to be known, and they got 4 pages of her donos. Here's what they look like. Who is she giving this money to? All right. So on May 2nd, the judge's GF made contributions to the Four Freedoms Democrat Club, Chelsea Reform Democrat Club, the month prior to that. 175, 350, $50 here, $50 here, $210 here to the Chelsea Reform Democratic Club. Democrat Downtown Independent Democrats, $250, another $250, $500 here to the Jim Owls Liberal Democrat Club. Here's some more Democrat donos from the Judge's GF. $250 to another Jim Owls. Sylvan for New York got $100. More Democrat committees. The New York Democrat Committee, like that is that, like the hard Democrats, like that's hard party stuff. Okay, $25, $50 to them. She's loosening up her spending a little bit. Coda district leaders, Friends of Kim. Oh, we got Friends of Kim, whoever that is. We got Harvey for New York, Jim Owls. We got 4 Democrat freedoms. Now, here you go. More troubling than even the fact that these contributions exceed the lawful limits, many, if not all of these organizations actively support the Attorney General, Tishy Letish. For example, the president of the Grand Street Democrats published an op-ed in 2020 proclaiming Leticia James is the last line of defense against the Trump administration, which is crazy. And she donated to the Grand Street Democrats, right? They're all over the place on these lists. Grand Street Democrats. Let's see, we saw those at the beginning. And Chelsea Reform Democratic Club, they're in there. And New York for Alex. Here there it is, Grand Street Democrats. Wanted to make sure I found it actually in the document. So Grand Street Democrats specifically showed up and spoke, and they said that Letish, who's prosecuting this case, is the last line of defense against Trump. So also Greenfield contributed to Grand Street Democrats, which endorsed Tishy in 2022. Here's what they said. They said, while progressive AGs like Tish James, okay, that's her account, while they have worked tirelessly to fight back against Trump's agenda, Republican AGs actively work to support and raise money from his lies and lawlessness. And so that's where she's sending her money so that they can keep speaking out against Trump. Now, moreover, they say while this case was pending, Allison Greenfield attended a Grand Street Democrat events where speakers openly advocated for Joe Biden. She's politically active, shows up at a rally. Speakers also commented to significant applause there, saying that on the fight against the developments and profits of big real estate and fighting, saying that there should be consequences for former President Trump. Showing up and they're railing against real estate and Trump specifically. Now, all these contributions and these partisan activities, they violate the judicial code, Engoron, and they're attributable to you, this court. And indeed, even as a candidate for judicial office, Ms. Greenfield was bound by the code, and it precludes a candidate from public election to judicial office from engaging in partisan political activity. It prohibits you from publicly endorsing or from even attending political gatherings. So she should have known. Now, at base, a judge or a non-judge who's a candidate shall maintain the dignity of the appropriate judicial office. But here, Judge Engoron, the principal law clerk, your GF, who sits on the bench next to the presiding judge, sitting there, co-judging and consulting with him on a real-time basis about nearly every ruling, has engaged in literally prohibited partisan political activity with respect to the parties before the court while their case is pending before the court. It's about as partisan and corrupt as you can be. She's sitting there next to you, and while this case was going, she was actively involved making donos and showing up at campaign events, speaking about the parties in this case. And she's sitting there co-judging the case with you, Engoron. So he must really be in love with this woman or something. Now, the court's demonstrable bias is something you can extract from there. They say the foregoing partisan conduct from both this court and his law clerk has resulted in biased rulings throughout these proceedings. First, the court refused to transfer this complex case to the commercial division where it unquestionably belongs. And shortly thereafter, on November 22nd, before the Attorney General even opposed Trump's motion to dismiss, or any discovery had even been exchanged, this court determined the trial would begin on October 2nd, the very date that Tish suggested in her preliminary order. The court ignored both the presumptive 15-month standard in complex commercial cases, just said, no, we got to get this done before the election, hello, and also dismissed the burden imposed on the defense to review millions of pages of documentary evidence and evaluate dozens of witnesses. Now, this compressed schedule also provided a massive advantage to the Attorney General, who had already been working on this case for 3 years in preparations for the filing to take it to trial. And thereafter, despite a letter request and a motion by the defense, the court refused to postpone the trial, stating it did not see a need for extensive disclosure. You don't even need to know what is in their evidence, because we're living in a kangaroo time. Now, on January 6, 2023, Engoron denied Trump's motion to dismiss in their entirety. On June 27th, the First Department on appeal of this court's decision modified the underlying decision in order and dismissed the Court of Appeals certain claims as time barred, right? The statute of limitations said that Tishy was bringing these in and the allegations were too old. On September 5th, with an impending trial date and no action by this court to comply with the First Department mandate, Trump moved for a brief stay of the trial until we could rule on our motions. We submitted a 15-page memo, but less than 24 hours later, this court uploaded an unsigned order to show cause with the notation, "Decline to sign because defendants' arguments are completely without merit." So they said, okay. So we were then forced to commence an Article 78 proceeding to compel this court to comply with the First Department's directives. This court finally came out September 26 and issued a decision on the summary judgment 5 days before trial was scheduled to begin. That 35-page decision from Engoron denied Trump's motion in its entirety and granted Tish's motion for summary judgment. She wins, Trump loses. Now, the court also granted Tish's motion for sanctions against Trump's counsel, and this left Trump in an unprecedented decision of discovering what claims and issues would actually be tried at trial just literally a few days before beginning a months-long trial with dozens of witnesses, right? Everything just got decided at the very last minute, and they had to move forward. Now, the trial began as ordered on October 2nd. On October 3rd, the court, on its own, imposed its first gag order based on Trump's reposting of the principal law clerk's Schumer photograph, right? Trump just posted what she posted. And the judge said to everybody in the case, consider this statement a gag order, forbidding all parties from posting, emailing, or speaking publicly about any members of my staff. Now, any failure to abide by this directive will result in serious sanctions. And they say in contravention of the judicial rules and the First Department, the court subsequently sanctioned Trump for violation of that gag order. On the 20th, sua sponte, again, the court issued another order finding Trump violated the gag order again because the website still had the post up. $5,000 for the first violation. Trump got sanctioned. On October 25th, during Cohen's testimony, the convicted perjurer who's lied multiple times now, Engoron, on his own, raised President Trump's statement to the press made moments before in the hallway outside the courtroom. Judge said, it's just brought to my attention that the AP reported, now I wasn't there, this is the AP, that Mr. Donald Trump just stated the following to the press outside the courtroom. He said, this judge is a very partisan judge with a person who's very partisan sitting alongside of him, perhaps even more partisan than he is. And the judge said that Trump was talking about his GF there, but Trump said he was talking about Cohen. They say, now it's very easy for the public, for anyone to know who that person is. This court simply assumed President Trump was referring to his GF when Trump testified under oath. He has said, I was referring to Mr. Cohen. But the court nonetheless concluded, relying on its own testimony, describing the layout of the bench and the witness box. The court said this. Before that, Trump posted this. He said, this is Schumer's girlfriend, Allison Greenfield, is running this case against me. How disgraceful. This case should be dismissed immediately. So the judge then said, okay, that was in the first point. Now, I thought Trump said something in the AP in the hallway. He says, I listened to Trump. The judge says, as a trier of fact, I find that Trump is not credible, that he was referring to my law clerk, the principal law clerk, who is sitting much closer to me, who doesn't have a barrier, because that would make things a little bit more difficult for them, whom I believe has been accused by the defendant of being partisan or Democrat or partisan Democrat. I hereby fine you $10,000, which is on the low side, to be paid within 30 days to the lawyer's fund for client protection. That's the judge. She has like 3 pages of donations to Democrats. She is Democrat and partisan. So the court thereafter issued a second gag order and said, guess what? Trump pays his 15 grand and the counsel, the lawyer, are also prohibited from communicating about my GF. Now, finally, Trump's defense continues. This court's evidentiary rulings throughout the trial have been both legally misguided and biased in favor of Tish. For one, this court has overruled, as a matter of course, any objection to the AG's introduction of time-barred evidence under the guise that it bears on potential injunctive relief, despite being clearly rejected by the First Department decision. They unequivocally dismissed as time-barred any claims that came before July 2014. They said there's a tolling agreement that already accrued. But the First Department directed literally this trial to be circumscribed, okay? You cannot try all of those old claims. But nonetheless, Engoron overruled summarily Trump's continued objections to the documents that predate that period. They also said any testimony is also admitted. So the court has also permitted the introduction of hearsay testimony under inapplicable exceptions and in some cases without identifying which defendant it might be admissible against. It's a total free-for-all. They say additionally, this court denied Trump's motion in limine to preclude expert testimony that was explicitly keyed to filling in the gaps in their case with testimony that she failed to elicit from witnesses. So she's letting the court is letting Tish fill in the holes. Now, the Attorney General never elicited any testimony from any bank representative as to what, if anything, the banks would have done differently if approving the subject loans. Instead, the court permitted the Attorney General to backfill the hole in her case with the testimony of an expert. And so they're going to say, Your Honor, this is the standard for a mistrial, okay? All of this is case law, and here, all of this is appropriate. They say, you have met the standard as detailed by your own public comments in the Wheatley newsletter. They're beyond the pale. The court is indisputably bound by the code, which says you can't comment on pending or impending cases. A judge cannot do it. But regardless of the venue and the fact that the links were often posted without comment, the court's repeated publicizing of its own rulings and even worse, previewing forthcoming rulings gives an appearance of impropriety in contravention of the code. Now, this court has also violated the code by permitting his principal law clerk, his GF, to make political donations in excess of the permitted amount. This conduct is directly imputed to the court under the code. And she has been acting as a de facto co-judge, which also violates the code. There is an unprecedented arrangement that exceeds the discretion of this court and creates the appearance, if not the fact, of a co-judge presiding over this trial. Having the principal law clerk sitting on a bench leads inexorably to the conclusion that she is acting in accordance with her overtly public and partisan views to essentially implement what, quote, the political people who support me want me to do. The notion she somehow provides impartial input is based on her own words and conduct untenable. It creates an appearance of impropriety which violates the code, and court employees are also included under the rules. The law clerk, Greenfield's extensive partisan activities during the pendency of this case also violate the code. As set forth in detail, public postings with prominent Democrats, contributions to Democrat causes in excess of the rule, including people like the Grand Street Democrats, attending highly partisan political activities, all violate the code and give us concerns about her bias and impartiality, especially as a co-judge. Now, all of this conduct, including supporting political groups that vehemently opposed President Trump, was singularly partisan and thus in violation of the code. And of course, the code says that the courts must be faithful to the law. Judge Engoron, in sum, There is simply no room at the bench for such open and obvious indicia of bias. Indeed, left unchecked, the introduction of such demonstrable pro-attorney general and anti-Trump real estate bias into a case of worldwide interest involving the frontrunner for the presidency of the United States impugns the integrity of the entire system. And so Judge Engoron, the gag orders and the enforcement thereof reveal the court has christened itself camera stellata, judge, jury, and executioner, proceeding sua sponte on their own to act against President Trump in violation of the Constitution, the judiciary, and the First Department rules. This star chamber approach is particularly indefensible when the gag orders actually shield the court itself from public criticism of perceived bias, one of the most fundamental rights of the First Amendment. It's the whole point. The court's efforts to silence the lawyers from objecting and creating a record of what anyone could observe publicly taking place in the courtroom during the trial plainly augments the appearance of impropriety. They changed the camera angles. First, the October 20th sanction was raised by the court on its own. In violation of the rules, a court is permitted to summarily punish contempt in the absence of motion only where the offense is committed in the immediate view and presence of the court. And so the continued existence of online posting is indisputably outside the view of this court. So Trump should not have been sanctioned for that first 5,000. Now, setting aside the procedural infirmities, meaning that the judge is just doing whatever he wants, of punishing Trump, this court has made clear that it would like nothing more than to manufacture reasons to sanction the frontrunner of the 2024 presidential election because it disagrees with him about the existence of bias. And second, Judge, you sanctioned him again in October. You did that on your own after the court learned of the comment to the AP. Now, that remark was also made outside the court's presence, but again, you punished him even though you had no authority under judicial law to do it. And you even listened to him and said that he was not credible. And they said that a judge cannot serve all multiple roles as the indicter, the complainant, the indicter, the prosecutor, and the judge. You can't do all those things. But here, the court has served as the complainant on its own, raising the issue of the statement to the Associated Press. Okay, nobody complained about that. You heard it, Judge, and you brought it up. You also then indicted him under the statement. You brought him up to give testimony. Then you questioned him as the prosecutor, and then you deemed Trump not credible, and you sanctioned him. Now, you conflated the roles. You're a judge. The rules under New York law say you're not supposed to do that. We have principles of due process and fundamental fairness, or used to. They say the court here effectively assumed the advocacy role traditionally reserved for other people, and it did so to silence everybody from preventing public comment about his law clerk. Now, even if Trump had referred to the law clerk, which he did not, the veracity and the propriety of the conclusion that she is partisan has only been bolstered since the statement was made. Having made credibility findings of testimony, the court compelled in violation of the rules, all the while presiding over the bench, the court cannot unring the bell of its own bias. Ooh, that's good. Can't unring the bell of its own bias. The entire episode establishes fully the court has already determined Trump is incredible based on nothing more than the court's own surmise. To proceed with a bench trial under these circumstances would be the apogee of bias. Now, third, on November 3rd, the court impermissibly extended its gag order and extended it over to counsel. They were only seeking to preserve the record for appeal. But this unconstitutional order, it interferes with the lawyer's ability to even advocate for their clients. Like, talk about ineffective assistance of counsel. Like the judge said, you can't do your job by raising objections to the judge's own improprieties. And was entered after, arguably, because of comments by counsel on the record about his principal girlfriend, GF. Now, in the written order, this court again specifically named Trump's principal's attorneys and accused them of making repeated inappropriate remarks about his GF, falsely accusing her of bias and improperly influencing the trial. Now, as the record reflects, the record observations of counsel were both accurate and well-founded. But nonetheless, the gag order from Engoron curtails the defendant's rights by precluding his lawyers, Trump's lawyers, from abiding by their ethical obligations to create a thorough record on the appeal. They can't do their jobs. Given Greenfield's obvious and demonstrable partisan activities and her, quote, de facto role as the co-judge, the notion of impeding counsel's ability to establish a record creates an unquestionable appearance of bias and impropriety inconsistent with the code and the Constitution, which guarantees a fair trial. Now, wrapping up, they say, as noted above, the court's evidentiary and in limine rulings at trial also demonstrate bias. The reason for these rulings appears plain. The court intends to, in contravention of the First Department's decision, consider, quote, evidence rather than claims that accrued prior to 2014 and grant overbroad and unauthorized injunctive and monetary relief. Now, the court's rejoinder, Engoron's, throughout the trial, effectively that it is uniquely capable of separating the wheat from the chaff, neither vitiates the harm now nor the inevitable harm that will result from an adverse judgment. The court's desire to, quote, get the whole picture and not, quote, blind itself does not justify admitting time-barred hearsay and other improper expert evidence. And that's exactly what we've been saying the judge has been doing, that he knows that none of this stuff can actually be used, but he wants to hear it, and then he'll say it's the totality of the circumstances. It's all the things considered, which is why the things he can rule on will be way harsher because it is a pattern. They say, Engoron, in sum, your bias is exemplified well by remarks made during during his testimony. Specifically, Engoron, you said, this court is not here to hear what Trump has to say. Couldn't have said it better ourselves. We know. The court expounded as follows. They say, well, Mr. Case, I think you said several times we should hear what he did, what the witness has to say. No, I am not here. These people are not here. And the Attorney General is not here to hear what President Trump has to say. Of course not. No, of course not. It is a show trial. He is there to just take his abuse, be punished, be disgorged, have his whole business taken from him, and every time he tries to defend himself, gag order. Trump, my lawyers need to speak up and make a record about your unconstitutional orders here. No, they're gagged too. Don't do it, Chris! As his GF is sending him love notes, and they're adjusting the camera angles. The role of the court, says Trump's defense, particularly in a bench trial, is to carefully listen to and consider the testimony of all witnesses without bias or predilection. The foregoing statements, Your Honor, especially coupled with the court's prior and inappropriate finding that Trump is not credible, certainly creates an appearance of bias. The record facts also lead fairly to the conclusion that the court has predetermined the outcome of this proceeding and is merely going through the motions before it ultimately does what it wants and doles out its punishments. Now, on a fundamental level, the way to dispel the appearance of impropriety is not to double down on precluding comment on it or by simply ignoring the manifest existence. At this point, the taint of these proceedings is both obvious and irreversible. Worse even, the court has abrogated its constitutional responsibility to ensure that each defendant, including President Trump, receives a free trial free from even the appearance of impropriety and impartiality. Therefore, given the demonstrable partisan bias present here in your courtroom at the bench at trial from you, the only way to maintain public confidence in a truly independent and impartial judiciary and the rule of law is to bring these proceedings to an immediate halt. For the foregoing reasons, Trump's defense respectfully requests that the court grant a mistrial and grant any other such relief and further relief it may deem proper. Signed by Alina Abbe, right there, submitting that November 15, 2023, Alina Abbe and Robert Clifford S. Robert, who is actually the lawyer, it sounds like, who wrote the affidavit. This also signed by Christopher Keese, who submitted the filing. Of course, a very, very nice and obvious motion that this trial is basically insane. Look at all of these donos from the judge's clerk. And so, of course, my friends, thank you for sharing this one so that everybody else can see what happened inside. The judge is trying to gag Trump and his defense, trying to gag even the lawyers from speaking out about it, but they put together a nice filing and it details exactly all the improprieties there. And so we'd love it if more people saw this one for sure. So thanks for sharing it around, and we appreciate it. Now, what also happened there in trial is Alina kind of went missing a little bit, and it's not bad. Doesn't really mean much of anything. She submitted that filing, of course, so she's still on the case, but she was not there in court. And the reason being is because there are rumors that a settlement might be being devised in the case. You can see this here. Not sure what's going on, but they have said on Tuesday, various reporters on the scene have said that in New York, where the fraud trial was set to be, that it had been delayed. Well, Abbe was conferring privately with Judge Engoron, and later she emerged from the meeting and left the courtroom. We've been waiting for this afternoon session to start. Judge Engoron first conferenced privately with Alina Abbe, who then left the courtroom and has not returned. Nobody really knows why. And so similar observations, could be a settlement, could be something else, but very curious, they're saying. Sitting here 25 minutes late on our planned return, Abbe walked out of chambers, and then the AG's attorneys went in. Recently, Trump complained about a lowball settlement offer. Could there be a settlement? We don't know. But today's trial was not too exciting. We remember that Jason Flemings was back on the stand for a direct examination. We got a couple quick updates here. Klasfeld was there reporting. He says that defense expert Jason Flemings resumed his testimony in the Trump civil fraud trial, said questioning begins again with him talking about GAAP, okay, generally accepted accounting principles. Trump's lawyer says, all right, Mr. Flemings, in the statement of Trump's financial conditions, how many GAAP departures are disclosed in the compilation report? And remember, GAAP is generally accepted accounting principles. And when Trump would create these statements of financial condition, there would be a bunch of documents in there. And there was a disclaimer that said, we did our assessment. This is what we think our condition is. And they would also make some notes, but they would say, there are exceptions to the generally accepted accounting principles that we have made in this assessment, and just so you know. So, Mr. Flemings, in the statement of financial condition, how many GAAP departures from the general practices are disclosed? Well, they didn't hide anything. It's not fraudulent. They told you. We know the general principles say you do it this way. We did it this way. Here's why. He says, oh, there's quite a few. Now, they say here, Engoron rejected these defenses, but they're trying to bring it up. So Trump's lawyer, Jesus Suarez, is up. He says, were these disclosures just boilerplate? Flemings says no. They ask another question, and there's an objection. He says, sustained, but it was a good try. Morning recess, not much there, kind of quiet. Now, Flemings, his testimony then turns to the accountant's obligations to address the obvious GAAP departures. So what do you do when there is a GAAP departure? Don't you disclose it? And he says, yeah, I don't even know what the testimony is. Looks kind of quiet. So Flemings, the cross-examination begins. Tish's lawyers come up. They say, Mr. Flemings, have you reviewed Trump's statements of financial conditions from 2011 through 2021? Yeah. Can you confirm that they had adequate disclosures in them? He says, well, I don't believe I did that for all of the disclosures. Like, I don't think I looked at all of them. Well, those are the years at issue in this trial. I said, well, I can't really be the judge of that. He says, the standards are very permissible. All right. So if it's a gap, if you're saying there's a deviation from the GAAP principles, it's pretty permissive. So as long as you just disclose anything, I think it's probably good enough. Do you believe it's appropriate, Mr. Flemings, for a client to perform 12 calculations, choose the one that's the highest, and not disclose any of the others? Fleming replies, yeah, that's correct. It's appropriate for them to do that. Are you discrediting the testimony of another accountant, Donald Bender? And he says, no, his testimony is inconsistent with the standards applicable to the compilations. His testimony is inconsistent, so he's wrong and I'm right. And that's basically all we got out of the trial today. InnerCityPress was also stopping by over there, and he had a couple things to say. He said that they were there back in trial. Engoron returned to say that the Trump org had filed a proposed order to show cause, and would the AG's office like to respond? And I've not seen that document, so I'm not sure what that is. Here is the headline of it. It says, upon reading and filing the affirmation, of Clifford Robert upon the pleadings and therefore and having sufficient cause. It sounds like the Trump organization is complaining about what the Trump defense just lodged there. And so here is all we got. They say tomorrow, a lot more, today was a lot more talk about Gap. And so not much more happening in court, in trial by Trump's defense. We just had Jason Fleming's there, and it sounds like it was pretty short trial day, but we did have the big motion for a mistrial. And of course, my friends, there will be a lot more to come on this. There's no doubt that Tishy and her defense or her government will respond to this. We'll see what Engoron does. This will put a nice line in the sand. They can appeal this and ask what the Court of Appeals has to say about it there in New York. Of course, we'll be here continuing to cover. I hope you join us and subscribe. Thank you for checking out robertgovea.com. You can access all the PDF documents that we went through. The mind map is there. You can get daily show reports. Sign up for the newsletter so that these segments are delivered to your inbox. Don't forget to subscribe and share this with a friend or family member so they can see what the heck is going on in these cases. And we'll look forward to seeing you on the next one. All right, my friends. Now, we've got to stick with Trump, but a new player is entering the Trump litigation game. And this one, I think, this one is pretty precarious for them. I think this one could backfire for them. But let's unpack it. Hunter Biden is subpoenaing Donald Trump. They say that they need documents from Trump, and apparently he's got some information about how corrupt the DOJ is, the same DOJ that we call corrupt, for not prosecuting him, for having people like Leslie Wolf warn his lawyers about raids on his storage facilities and so on. No, he says the Trump DOJ was corrupt, and now he wants documents. He sent a request for a subpoena in, asking the Delaware judge to order Trump to comply. And I'm thinking to myself, okay, you want Donald Trump to show up and tell the court everything you know about, he knows about Hunter? Okay. Can he have some of his boxes back that his daddy raided from Mar-a-Lago? I don't know. But this is what Hunter is requesting. And this came from his lawyer, Abbe Lowell. And here's what it looks like. Not a super long filing, 16 pages. And Abbe's a competent lawyer, no doubt about that, right? He's very aggressive. But I don't know if they're maybe biting off a little bit more they can chew here, because what if Trump says yes? What if they just come in and say, we've got a lot to share with you, and we're excited to do that? So here is what Hunter's defense says. And to get our bearing straight, this is Hunter being prosecuted. This is the United States of America versus Hunter in these, so-called prosecutions for gun and tax charges. It's in the District of Delaware, and this is in front of the same judge that we've been following, who did not allow the DOJ to get away with their scam plea deal. But this is Mr. Biden's motion for an issuance of a subpoena for documents and a memo in support. They say, Your Honor, Hunty is here, and through his lawyer, we move this court to enter an order for a subpoena ducis tecum that be issued for the following individuals. Guess who? Hunter wants subpoenas for Donald Trump, who they call Mr. Trump. Very rude. It's President Trump, jerks. William Barr, former AG, Richard Donahue, and Jeffrey A. Rosen. They say, pursuant to the rules of federal criminal procedure, they say, we need these subpoenas, Your Honor, so that Hunter has sufficient time to review the materials in advance of trial. The grounds why we need these things are included in this document. Now, they say, hey, Your Honor, law enforcement agents have testified that the federal investigation of Hunty, led by the U.S. Attorney's Office in Delaware, began in late 2018 under President Trump. That wide-ranging investigation has spanned more than 2 administrations, lasted more than 5 years, and is ongoing. Now, that probe, investigating years of Mr. Biden's tax affairs, as well as events surrounding his purchase of a firearm that was recovered 11 days later, made up the basis of these claims. The culmination of this 5-year inquiry was prosecutors and Mr. Biden agreeing that he would plead guilty to 2 failure to file misdemeanor charges and take a diversion deal to resolve the firearm claim. Now, the prosecution, they say, unilaterally reneged on it. That's when the judge busted you guys. Now, the collapse of the agreement and the prosecution's change of heart eventually led to a new indictment against Hunter that's currently before the court. But they say the initial investigation was born out of a wider probe into Hunter and his taxes and foreign business dealings. Now, additionally, it's been reported and revealed in the now public IRS investigative files concerning this case that was released by the House Ways and Means Committee and by the DOJ that Bill Barr opened a dedicated channel in Pittsburgh to receive information about Hunty coming from Trump's attorney called Rudy. Now, that effort to review and vet any material was coordinated by Richard Donahue, a U.S. attorney from the Eastern District of New York, and Scott Brady in Pittsburgh. When Mr. Donahue was elevated to serve as the principal AG at the DOJ in 2020, the IRS files reveal that he further coordinated with Pittsburgh and with the prosecution team in Delaware, including issuing certain guidance about the overt steps in the investigation. So they're rewinding the clock, right? All of this cover-up there was a lot of cover-up, by the way, in 2020. I mean, Leslie Wolf and all of these people were actively, there. So as Deputy Attorney General, Mr. Rosen interacted with teams investigating Mr. Biden, both in Pittsburgh and Delaware. And in the lead up to the 2020 election, IRS case files show certain investigative decisions were made as a result of guidance provided by the AG's office, Deputy Attorney General's office. Now, testimony and other investigative files provided by the IRS agent Gary Shapley, the IRS whistleblower who we've talked a lot about here, also reveal that around 2020, all aspects of the investigation needed to be vetted by David Weiss and Donahue. So in addition, public reporting reveals certain instances that appear to suggest incessant improper and partisan pressure applied by then President Trump, to these people to investigate Hunter. They say, for example, on December 27th, Deputy General Donahue took handwritten notes of a call with Trump and Acting Attorney General Rosen, showing that Mr. Trump instructed Mr. Rosen and Mr. Donahue to figure out what to do with Hunter Biden, and indicating that Trump insisted that people will criticize the DOJ if he's not investigated for real. Now, the notes were released by the House Oversight Committee as part of their J6 investigation. Now, additionally, they never really investigated him, as we know. Now, additionally, former Attorney General Barr's latest book recalls an instance in mid-2020 which President Trump called Mr. Barr and inquired about the investigation into Hunter. And Barr said, "Dang it, Mr. President, I'm not going to talk to you about Hunter, period," is what Barr wrote in his book. So these confirmations of communications give more than a mere appearance that Trump improperly and unrelentingly pressured the DOJ to prosecute Hunty. And for his part, Trump has made a plethora of concerning public statements calling for an investigation into Hunty while in office and not. They said, here, the former president has also incessantly called for law enforcement, the media, and the public to go after Hunter. He tweeted the following on his X account. And all of these are from the time that he was in office, right? So this would be November 15th. He mentioned Hunter. December 12th, he mentioned Hunter, 2020. December 12th, he mentioned Hunter and Biden and Joe. Says Barr's not doing anything. Barr will do nothing. A new group of people are coming in. Same thing with Durham. We caught him cold. Trump also tweeted December 17, 2020. I have nothing to do with the potential prosecution of Hunter or the Biden family. It's just more fake news. So he said, I have nothing to do with it. Wow, the corrupt Biden DOJ, he posted June 2023, just cleared hundreds of years, this is on Truth Social, of criminal liability by giving Hunter a mere traffic ticket. Our system is broken. Okay, so this first batch, these first four are from when Trump was actually president, and then it shifts over to more recently. And again, like he has no pressure now, right? He can't order anybody to do anything. So the call for Mr. Biden to receive a certain penalty and other incendiary comments are what Trump said. And so these statements necessitate ample justification for personal records. They say, as the post detail above, there has been a sustained, almost nonstop public pressure campaign by Trump to go after Biden. First made public in June. After Biden agreed to plead guilty to resolve these two charges, Mr. Trump blasted the agreement as a sweetheart deal. Ron Johnson said it was a light slap on the wrist. Rick Scott called it a mockery of our legal system. James Comer called it a sweetheart plea deal. And so upon the news of the parties' agreement, Republican allies cheered when it didn't happen. They said it was great that the deal got killed. This is justice being served. And from that point forward, Republicans are pushing for more severe charges against Mr. Biden in an effort to make him an election issue. And that outside pressure culminated in Special Counsel Weiss's then changing course and bringing this indictment, now charging him with 3 felonies. So Hunter is the victim of political prosecutions. And Republicans say this is not enough. The very same day, Comer said mountains of evidence reveal that Hunter likely committed several felonies, and Americans should apply and expect the DOJ to apply the law evenly, saying that everybody was involved in much more fraud and more serious crimes. They say it's clear that no measure of the charges against Mr. Biden will ever be enough to appease Comer and Smith and their MAGA allies. And as anyone can tell, it's not just pressure from the Trump executive, it's also outside pressure from congressional Republicans. And so, consequently, they say, Your Honor, Mr. Hunty now moves this court to issue 4 subpoenas directing Trump, Barr, Donahue, and Rosen to give us the following documents. Now, I'm curious what these are. Everything from January 20th to 2017 to the present. A lot of documents. And I'm curious if Trump is going to be, excited to deliver these. I mean, he probably has a lot of information, but they stole all of his boxes from him. Now, all documents they want and records reflecting communications between the subpoena recipient related to Hunter, all documents from DOJ officials. He's not in there, right? He doesn't have control of these anymore. So, it's he probably needs to go to the National Archives to get these. All personal records, diaries, journals, memoirs, memoranda, notes concerning Hunter Biden, but not limited to any formal decisions to prosecute Hunter. So all of Trump's notes. Any documents produced to the January 6th committee as well. They say all this information would be admissible, and to date, the defense has not gotten any of this information from the DOJ. Now, the curious thing about this, right, is what is the DOJ going to do? Like, they might want Trump's journals and memoirs. Like, they might want Trump, okay, sure, get a subpoena. Go get it all. And, like, Hunter is going to, the people responding to Hunter are his dad's DOJ people. So you can see why this is a little bit strange. Now, they say, nevertheless, this information is essential to Hunter's defense. Before the government intones its stock phrase, this is no fishing expedition. The statements described in this motion actually occurred, and the events actually transpired. And Mr. Biden actually seeks the information from 3 former DOJ officials and the former president. It's the heart of his defense. And each of these DOJ officials had known contacts with President Trump about Biden, and so it's still ongoing. And these handwritten notes show that this stuff does exist. And so here is the standards for the subpoena. They articulate what the rules are. They say here, each bit of information that we seek is very relevant, and it impacts the fundamental aspects of fairness. Subpoenaing Trump knows full well that improper pressure on prosecutors to bring criminal charges for political reasons is grounds to dismiss an indictment. And so here, a subpoena for Barr is also justified. They tell us that our requests are only seeking communications and records that are within the scope. From a Fifth Amendment perspective, it's essential for Hunter to know whether anyone has improperly discussed or encouraged or endorsed or requested any prosecution of him. No information would demonstrate that fact. And so here's my point. Like, if they grant this for Hunter, are they going to grant this for Trump? Like, okay, here's the problem, guys. If the court says, sure, you can have all of Trump's DOJ memos about prosecuting you, can Trump say then, I would also like all of the DOJ memos about prosecuting Trump? Like, can he get Biden's notes? Can he get all of those things about all of the conversations with Merrick Garland and Jack Smith and all these other people? Like, does the standard apply? Is this the new standard? Because I think Trump might like this standard. Now, this is especially true in light of the fact that no new evidence has emerged. They say the prosecution's change of heart now only appears to be political pressure. Well, that's because they got caught, yeah. And not anything new that was discovered. They say information that we're seeking is all admissible. It would be material to Hunter Biden's defense. And it's very specific, right? It's not a fishing expedition. We only seek personal records reflecting stuff that's related to the issue of putting undue pressure on government officials. It's only seeking information from relevant officials, former DOJ officials, and it's limited in time. So Biden seeks specific information from these people. We need to know if this is vindictive or selective prosecution. And we need to know from these known contacts. So for the foregoing reasons, Mr. Hunty respectfully requests the court enter an order pursuant to our subpoena, to our request, issuing a subpoena that would allow Mr. Biden to go and get these documents. He needs time to do it, and it's all valid under the rules. Signed, sincerely, Abbe David Lowell, Hunter's attorney. And it's a good filing, right? I think this is something that you would be filing if you had the DOJ on your side and you had your daddy who was running them, and you were a little, he had some serious bravado, and you wanted to potentially open up a can of worms. Maybe that will happen or not. Or maybe the DOJ will agree with them and say, sure, yeah, grant Hunter whatever he wants, Your Honor. No objection. We're going to see what the DOJ does on this, because they got caught with their hand in the cookie jar. They tried to cram this ridiculous plea deal through, and they got busted. And now they're having to put on this show like they're actually charging Hunter with actual crimes. And now Hunter is escalating this. Okay, he's saying, I'm entitled to this. The DOJ is going to have to fight it. And they cannot be happy with him about this. So it's going to be very fun to watch what their response is. They're kind of caught between a rock and a hard place because they tried to give him an out and the whole thing got botched. And so now they're faking like they're actual prosecutors, and nobody really believes them. But that was the request for the subpoena. This is what it would look like if the judge signed off on it, which we have not seen it signed. It's just a form. But they filled it out for us. They said if the judge signs it, it would go to Donald John Trump. And they said here that you would have to comply with attachment A, which of course are all the documents that we just read through or just discussed. And so this is what it looks like. If the judge signs it, these would be the instructions that would show up. These would be the documents, everything from the relevant time period about the decision to investigate or to charge Hunter. And so we'll see what the judge does about it. I'm also very curious to see what the DOJ says about this, whether they just, rubber stamp it. We love Hunter. In fact, his dad is our boss. So we'll be covering it, my friends. The Hunter sagas, the Trump involvement, and more. Thank you for joining us as we do. We'd very much appreciate you subscribing and sharing this video and this channel with a friend or family member so that they can join us as we unpack all of these court documents and more. And we'll be looking forward to seeing you on the next one. All right, my friends. Now, we got one final segment on the day before we wrap it up and hear from you. Let's see what we got cooking right now. A defense lawyer in the big Fani RICO case in Georgia admitted that he leaked those photos and videos to the media. Of course, we're talking about Sidney Powell and Jenna Ellis. They took plea deals, and there was certain proffers that were leaked that we covered here. And we were asking ourselves, how did those get out? And do they matter at all? Are they even relevant to other charges? Are they consequential to the Trump prosecution in any way, shape, or form? Well, we could be the judge. People can split hairs on that one. But we know a defense attorney released it, and he said he released it because America needs to know what is actually going on. It's this guy, Jonathan Miller. He's an attorney arriving to courtroom in Fulton County in that photograph, and he represents Mrs. Misty Hampton. And he said in court today, it was me in open court. And it was a little bit of a nerve-wracking situation because you didn't know how the judge was going to react. Everybody goes, oh, it was you. And I think everybody was kind of bracing for impact, but we'll have to see what Judge McAfee does. Now, about Miss Hampton and about Jonathan Miller, because we're going to hear him explain this in court in just a minute. He is representing Mrs. Hampton, who is charged with these counts, 32 through 37. And you can see this from this actual charging document, okay? Sydney Catherine Powell, we've already talked about her case a lot here, counts 32 through 37. Look below, Misty Hampton, aka Emily Misty Hayes, same counts 1 and 32 through 37, just like Sydney Powell. And we already know what this set of charges were, okay? It was a contract type of deal. From the indictment itself, it says, this was count 32, and this was a whole series of felonies based on just a series of transactions. So the first transaction was a contract. Sydney Powell entered into a contract with Sullivan Strickler, and Misty Hampton aided in the contract, okay? And so she was involved in the contract. They hired this company to go do the thing. They did the thing. They sent him a bill for the thing. They paid the thing. Felony, 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 felony for every one of the things. Now, this is important because what do the other conversations and the other plea proffers have to do with any of that? Anything at all? Not really. And so we're going to jump into the hearing today and try to get our way through it. We already have it queued up past a lot of the introductory stuff, and it's 8 minutes, okay? There was a bunch of different attorneys on this call because this was an emergency hearing. The videos got leaked. Fani says, you're going to wreck our case, okay? Our case, in my opinion, is already, their case is terrible, but they know that, and they say, if these proffers leak, maybe people won't want to take plea deals, or maybe people will recognize that these proffers and what these people are saying don't have any real bearing on our case. I've been hearing from so many people on the left that Fani's saving all of her good stuff for Trump and blah, blah, blah. Well, everything we heard from the media yesterday from Jenna Ellis and Sidney Powell, it adds nothing to the Trump charges at all. And so I think that really Fani doesn't want you to see how weak her case is. Like, people think that the proffers are like all these like damning bits of evidence that are going to obliterate Trump. That's it? We got Jenna Ellis saying that Dan Scavino made some drunk comments to her at a Christmas party. Okay. That's it. So of course Fani wants to tighten this back up so nothing ever gets leaked out. And the defense also wants to, I think, this to be tightened up so that their people can take these smoking plea deals. Okay. These are diversion plea deals. Jenna, Sydney, Kenneth, and Scott Hall will have no criminal convictions at all. No guilty pleas. They'll all be torn up and thrown in the shredder. So everybody kind of has an interest in keeping this thing under wraps. The only person who does not is really Donald Trump, who is being prosecuted here. And again, the outcome of this case, I think Fani is going to try to postpone this thing. I'm not sure that Trump is going to actually get to his trial. They're going to want all their eggs in the January 6th basket, and then they'll figure out what to do with this other stuff, okay? This is all just political albatross being hung around his neck. And so this is what it looks like in this particular situation because the videos got leaked. Fani wants a protective order in place. The defense wants a protective order in place so that their guys can keep taking smoking plea deals. Fani doesn't want any actual evidence getting out showing how weak her case is. And we're now showing up with the judge. Is there a consensus between the two sides? Can we get an agreement to have a protective order that requires the defense to go in and watch these videos in the prosecutor's office, or are they prohibited from communicating these things to the public? Can we see more of this or not? This is Judge McAfee picking up on this emergency motions hearing.
Okay, well, thank you for trying to make it work. I will say at the outset here, this is very much just a hearing where if anyone wants to be heard, they can be added. It was parties may be at. So if you need to run, Mr. Greenberg, I understand that. And as I understand it, it seems like there's been something of a consensus of an opinion forming for the majority of the folks here. So we can dive into that. So I was informed shortly beforehand that I think the state and all but one defense counsel have agreed on the protective order proposed by Mr. Schaefer. And so
who's a co-defendant.
I think that still raises a few issues, though, that we would need to work through, especially since it's not a unanimous on behalf of all the parties. So why don't we start it off with the state and Mr. Wooten or Mr. Wade, if there's anything that you'd like to address, we can do that. And then I'd have a few follow-ups for you.
Judge, we just moments ago received an email from Mr. Defendant Floyd's counsel indicating that they would agree as well to what the majority of the parties have already agreed to, which is the language in Mr. Schaefer's proposed order, excuse me.
Okay.
So it sounds like we're back in alignment. So maybe we're all unanimous.
I'll probably have to do another roll call then and go through everyone again just to make sure that that is the case, just so we have it all on the record. But since I've got you here, and I'll just start this with a few questions of my own. The primary difference here, it seems to be that the state originally had proposed what I would characterize as a blanket umbrella protective order, with just essentially anything and everything that's turned over that wasn't already public or wasn't already part of the defense file was going to be held under seal. Whereas my reading of the Mr. Schaefer's proposed order is that there's going to be this intermediary designation of something's going to be sensitive, and then that's going to be what's not allowed to be turned over. So it's not everything. Is that a fair read of that, Mr. Wade?
It is, Judge.
So what I'm wondering if this is just going to, if we're really going to, if it's just going to result in kind of another series of hearings where there are instantly going to be disputes over what's considered sensitive and what's not. So I have to say there was something about the idea of a blanket appeal that I think in a case like this is voluminous and complex and with as many parties that appealed to me. So do you want to, if you could walk me through where you are and where you've landed on this? I mean, for one thing, I think you'd noted a concern that if parties had the ability to just disclose aspects of their file to the public, I think you'd raise some concerns over that affecting the jury pool. Is that still a concern for yours? And is that going to be adequately addressed by Mr. Schaefer's proposed order?
It is a concern, Judge. It continues to be a concern, but I do think that Mr. Schaefer's proposed order does adequately address it. I think that the posture that we're in now, in terms of walking through Mr. Schaefer's motion, it does indeed address all the concerns that the state has.
It locks everything down.
The court's point is well taken. There could be a series of arguments between counsel as it relates to what is sensitive and what is not, though.
So it's very locked down. The defense might say, well, it's a little too locked down. We want to release that, and we don't know what's sensitive or not. And so the judge is saying, I don't want to have to deal with this order later down the road and try to figure out how to parse through it to deal with a discovery battle. I'd rather just deal with that now.
And Mr. Wade, the state's prepared at this point to go through their entire file and put this label on it and have this done?
We are, Judge. Everything that we've turned over, we believe that we're prepared to go through and say what's sensitive and what's not.
I think you'd indicated, or excuse me, in the proposed order, it indicated simply that what's going to be sensitive is something that should be confidential under applicable law. Can you give us any more guidance of what you anticipate the state labeling as sensitive?
Judge, I can say as one example, and I think this is kind of what brought us here, certainly proffers. Any videos of proffers would be an immediate example of something that would be sensitive. Anything that contains, of course, personal identifying information would be sensitive. Business records that are considered confidential or that would otherwise be protected because of some economic harm, if they were to be disclosed, would be sensitive. Largely in line, Judge, with what's covered under 1716.4, we believe, with just some additional, 1716.4D, with some additional things that I think just by their very nature make sense to be confidential. Like I said, for example, the proffer videos.
And I think one of the other lingering issues we had to talk about was the state's method of disclosing proffer videos, if any, going forward, going to change as a result of this week's developments.
Yes, Judge, if the court were to enter this order, the proposed order, as it is drafted right now, we would maintain the same system that we've been using, which is we would copy and provide copies of all that information over to the defense. So if this order is adopted, it would not change the process other than the procedures that are provided for in the order itself.
Okay. So with that, then let me just go ahead and cycle through again, and
All right. So
no need to add something if you think it's already been addressed, but I want to give everyone, all defense counsel, the ability to have their say, and we'll see if that's still the case on the behalf of Mr. Floyd.
sounds like we've
And
got
so
some
from
good
the top,
agreement
Mr.
here.
Sadow, anything that you felt
Mr.
you needed to
Sadow.
add?
No, Your Honor, we are in agreement with the proposed order as described by the state. And of course, it's Mr. Schaefer's proposed order. We've joined in, but we're in agreement.
All right. And for Mr. Giuliani, Mr. Stockton.
Judge, we're in agreement as well.
All right, Mr. Durham, on behalf of Mr. Meadows.
We're in agreement, Your Honor.
Ms. Bernard, on behalf of Mr. Clark.
Your Honor, our position remains that no protective order is necessary. However, if the court is inclined to enter one, then we do consent to the entry of the one that has been proposed by Mr. Schaefer.
So getting a little bit technical there. The judge will ask.
And
some
why don't you
questions.
think one is necessary, Ms. Bernard?
The information is largely already publicly available and has been released. And while we are certainly open to considering anything that the state wishes to designate as sensitive materials, the vast majority of discovery in this case consists of information that has been or is being heard in other tribunals on similar allegations. And so we don't think this is information that is being released in a number of forums in a number of different ways. And so we don't believe that any of it is necessarily protectable, though, of course, if there is any personally identifying information, as the state has indicated, we're not going to share anything inappropriately.
And because Mr. Schaefer's proposed order has that carve out for everything that's already part of the public record, wouldn't that address your main point there?
And that is why, we're not looking to create a fight over this, Your Honor. And if the court is inclined to enter a protective order, we believe that this one does balance the concerns appropriately by requiring the state to designate what it considers sensitive materials and providing us an opportunity to contest that. I did just want to make sure that our position on the record is that we do not believe a protective order is necessary, given the fact that the information that is relevant to this case and the discovery is almost all information that is of public import, public availability, and public record.
Okay, so two tracks are developing now, right? And this woman, Catherine Bernard, kind of broke the dam on this. Everybody's kind of, in agreement. Protective order is pretty good. A lot of people on the defense, okay, and partition the defense really into two kind of categories, and same with the prosecution, really. Like, there are two things happening here. There is a criminal prosecution and a criminal defense. That's in one category. And there's a political prosecution and a political defense in another category. And so if you are in the category of exclusively criminal prosecution or exclusively criminal defense, let me say exclusively criminal defense, your position on this gag order and essentially what this is, a protective order, and the disclosure of any evidence, it's really, inconsequential to you. Okay, you don't really care one way or the other. You care about your butt. It's in the hot seat. You're being prosecuted. Whether this goes public or not is really irrelevant to you if you're going to get a smoke and plea deal, which they're going to get. Okay, because Sidney Powell and Jenna Ellis, two people who were on the stages, all got their diversion deals where their felonies will be dismissed. Totally. They will have no criminal conviction. So if that's the environment you're in, you're kind of like, all right, we're trying to get a plea deal like that, and you're only trying to save your client's butt. You're not too interested in making political waves, okay, and causing a scene. All right, let me just go along. My guy's he's innocent, just going to take a plea deal. He'll get diversion. He'll get a couple years probation, be done in 3, he'll be done. That's in, a non-political case like this. But this is a political case, and there is a much, even maybe bigger text, right? The criminal prosecution is actually the subtext of the whole thing. It's actually a political prosecution first and a criminal prosecution second. Now, they would never want you to think that, right? They're always going to tell you, due process and justice of law and all, like what Judge Chutkan says. We know that's not true. It's a political prosecution first. And so, this woman, Miss Bernard, is communicating that, right? Okay, there's criminal prosecution going on here, but we don't want to be limited by a protective order. We still want to be able to communicate about these things because maybe from the other side, maybe they're not interested in taking a plea deal, okay? And maybe the people who went first actually got the worst deals, because what we're going to learn from them, and the reason why Fani doesn't want these proffers leaked out, is because we're going to know Fani ain't got nothing, man. Her cards, she's bluffing. She's holding up a stack of cards. I got a Sidney Powell conviction. I got a Jenna Ellis conviction. I got a Chesterbro conviction. And they got all these like really damning proffers behind the scenes. We're looking at your cards, man. You got nothing. You got nothing. So what they're saying is we want to continue to see these proffers. Yeah, let's put them all out there, because the court of public opinion and the partisan prosecution here will be called out. We'll be able to see that on display, and that may carry over to their clients, and it may make their clients get better deals. And if not, then we know what evidence Fani has at trial. And so this is where we're starting to see this kind of crack a little bit. And here is what it sounds like.
Okay, well, I'll note your objection and I'll make sure to address that in the order that we enter on this. Okay, over for Mr. Smith. I don't know if Mr. Samuel or Mr. Morris.
We consent to the entry of the order proposed by Mr. Schaefer.
All right, Mr. Nolowitz.
We consent to the entry of the order by Mr. Schaefer.
Okay, and Mr. Gillen, anything you wanted to add generally on behalf of Mr. Schaefer?
No, Your Honor, we consent to the proposal submitted by Mr. Schaefer.
I would hope so. Okay, I think it was Mr. Beaver on behalf of Mr. Still.
Yes, we consent, Your Honor.
We're getting close to
All right,
Mr.
Mr. Floyd, or not Mr. Floyd, but I don't know if it was going to be Mr. Harding or Mr. Kaczorow.
Your Honor, this is Chris Kaczorow from Mr. Floyd. As I indicated to counsel in my previous email, I don't think the protective order is necessary at all. It's not like there's a snitch being revealed in any of these proffers, which is the typical scenario that one would expect to see protective orders entered. But notwithstanding, because of all the defense counsel want to do this protective order, I don't have any objection to entry of this order that Mr. Schaefer has proposed. Only thing I would add is, because it came out in the state's motion that the appearance in the motion was made to seem as though it was the Floyd team that leaked a video. Now, I don't agree, first of all, that there was a leak at all. But secondly, that cost me time and aggravation, because I've had to field phone calls from press relentlessly.
Yeah, Fanny's
asking
office.
why Floyd leaked the video. And they got it. And I asked them where they got this information from. And the universal response was, well, the state put it in there. They put your email in the motion. Well,
Yeah,
the state didn't put the other email in the motion, which was that we had made a typo. Mr. Harding had originally said, we are the source of the leak. He meant to say, we are not the source of the leak.
Oh, not.
And so they played upon that. And that, quite frankly, is irrelevant to the motion, but it cost me aggravation. So I just wanted something on the record from the state, just acknowledging we weren't the ones that were doing it.
Well, I don't know if the state's in a position where they can actually say definitively who did or did not. If I recall from their emergency motion, they noted that you later acknowledged it was a typo. I don't know why the need for the email attachments, but here we are. And I think we've all, when we signed up for the case, agreed for some level of aggravation, but here we are. I think, was there anything else though, other than the note there that you think we need to address as it relates to the terms, exact terms of this protective order?
No, Your Honor.
Okay. All right. Thank you, Mr. Kaczorow. Or is it Mr. Cromwell on behalf of Ms. Latham?
Yes, Your Honor, and we consent to the proposed order by Mr. Schaefer.
We're getting close, working our way through the co-defendants.
Mr. Miller, on behalf of, excuse me, Ms. Hampton.
Here we go.
Judge, if I may, Ms. Hampton does not believe that an order is necessary, that this is one of the biggest cases the country has had.
True.
And that transparency is very important.
True.
Since I've been working with her for the last 2 years, she has always said that she wanted to be 100% transparent. And that is why we are opposed to having any kind of regulations on what we can expose and what we can't. But with that in mind, we will adhere to any court order that the court does, and will do so with diligence. But Judge, in being transparent with the court and to make sure that nobody else gets blamed for what happened, And so that I can go to sleep well tonight, Judge, I did release those videos to one outlet, and on all candor to the court, I need the court to know that.
Well, I appreciate that, candor, Mr. Miller. Is there anything else, though, you'd want to add in terms of, I suppose I would lodge it as an objection to the protective order, but not a vigorous one, I suppose. Is there anything else you'd want to add, though, your thinking behind
Thanks for telling me, but I didn't
why
even
you
know
felt
that.
these proffers needed to be part of the public record? Because it feels like that should be part of the
objection.
analysis that I had to do of
Yeah.
justifying a protective order.
Okay, if the court will entertain me, Judge, all four of those people that did their proffers, they stood in front of you, they did their plea, it was all recorded, it was sent out there for the world to see.
We watched it, covered
And
them.
to put those proffers, hide those proffers that show all the underlying things that went into those pleas,
which was nothing,
it misleads the public about what's going on.
Yep.
I don't believe that two of those defendants were directly related to my client. And I don't believe that either one of those hurt my client. If anything, I believe they helped my client.
Yeah.
And the public needs to know that.
He laughs.
So please keep that in consideration in any order that you do.
And Mr. Miller, how would your ability to eventually get that in front of the public at a trial be foreclosed by a protective order saying this shouldn't come out until it's determined to be admissible and it should come out at the trial?
It's a political prosecution.
Judge, the problem with that is that this is a very, very public trial.
Yeah.
We all know that. How many newspaper organizations are out there right now looking at it? That allows the DA's office to set the tone for the entire trial.
We got
without
convictions.
giving consideration to the other side of the coin. And that's what needs protecting, Judge. And the public has a right to know.
We do. We do. And we were here screaming from the rooftops, okay, that the Fani plea deals for Sydney and Jenna were jokes, were total jokes, because they're diversion deals. They're going to be dismissed. All of their charges are going to be dismissed. The guilty pleas that they took was a guilty plea proceeding. The judgment was not entered. The court did not accept a guilty plea. We read the documents here, but the media and Fani and everybody was saying, oh, these were smoking deals because behind the scenes, they got what they needed. Behind the scenes, they're going to come after Trump, and Trump's done for. I saw these lefty lawyers out there saying, well, this is just being done, you know, so that they can aggregate the claims and then prosecute Trump. It's all about the big fish, and these are all little peons. You know, what are you talking about? It was Jenna Ellis and Sidney Powell. The only other person was Rudy Giuliani up there with them. I mean, come on now. So the fact that the proffers show like nothing, and this defense attorney's like, they don't even hurt my clients at all. They help my clients. They're saying that Jenna and Sidney are going to incriminate my client. They're not at all. And we should be able to have that out there because there are two tracks here. It's not only the criminal prosecution in your court, it's also the court of public opinion. And we've got an election coming up, and we can't have this facade being played out that Trump and all of these people are really criminals and insurrection. They're not. They got smoke and deals, and there's no evidence.
Well, it's a good slogan, but do we have any case law that says pretrial discovery is a part of our First Amendment concerns? I know Mr. Clyde is sitting there just waiting to be teed up here on behalf of the media organizations.
Couldn't find any RICO cases with former
but it
presidents.
seems like having open files for everyone to start litigating the case before we actually get inside of a courtroom comes with a lot of side effects. I don't know if we've thought through.
Judge, I cannot argue with that logic. But so far as case law on these issues, I can quote you a couple of things, but note that the state's only case law that they came up with was a case that wasn't even related to Georgia from 1993. There's just not a lot of Georgia law on this particular issue.
Yeah.
No, I'll certainly grant you that. I think we're a bit unmoored here in Georgia on this issue, but I'll put all those thoughts in the order, which I will hope to get out by tomorrow morning. All right, Mr. Miller, if there's anything else you want to add, if not, I will move it on to Mr. Greenberg. Anything else, Mr. Miller?
No, Your Honor, I appreciate your time.
All right. Mr. Greenberg, if you're still with us.
Yep, I am, Judge. I got a better connection now. So we don't have any objection to the order. However, there was one issue that did come up, which was a suggestion that we would have to travel to the district attorney's office to view video interviews and so forth. Obviously, those are going to be key to trial. They're going to be the kinds of things that you're going to need to work with. So I'm hoping when they designate things as sensitive, they'll take into account the representations of people here today and that we're all professionals. And I'm looking at the screen, and while I don't know most of the people, it looks like almost everyone's been around a while and should be able to be trusted to act in a professional manner. And that we won't have to encamp in Atlanta in their office to look at discovery excessively.
Well, Mr. Greenberg, if I interpreted Mr. Wade correctly, I believe they withdrew that notion. And so whether designated sensitive or not sensitive, discovery is going to go back to the regular course of things. Did I capture that accurately, Mr. Wade? All right, I'm getting a general nod.
Yes,
and there we go.
That might have been while I was searching for a signal, Judge, because I had to switch from the 20th floor to the second floor.
Okay,
So,
understood.
Thank
All right.
you.
And so finally, I think we have on behalf of several media organizations, Mr. Clyde.
Okay, we'll listen to a little bit of the Mr. Clyde.
Thank you, Your Honor. As I mentioned, I'm here on behalf of the Atlanta Journal-Constitution and WSB-TV, but also the Associated Press, CNN, Gray Media, Tegna, Scripps, and the Washington Post. We do object to the entry of the protective order. It is a vigorous objection, Your Honor. And first, I'm going to address the need for the protective order, and then I'll speak to the terms of the protective order. First, Your Honor, we would submit there's just not a need for the protective order to be entered at all. The state in its motion, the defendants in their motions have basically referred to OCGA 17-16-4D. But that authorizes the court to enter a protective order only upon a sufficient showing that discovery required by that article would create a substantial threat of physical or economic harm to a witness. That just hasn't been shown, and that threshold hasn't been met.
Sorry,
and
law
it may
hasn't been
be
met. No order.
that both the state and many of the defendants now consent to some form of a protective order, but that has not been authorized essentially by the law. Essentially, what the state and the defendants are trying to do is get the authority of the court behind an order that will impose secrecy on information that's exchanged during the discovery process, notwithstanding how newsworthy that information is, notwithstanding how much it might inform the public about the circumstances of this case, but particularly in this case, the circumstances of an election that took place that's of extremely significant public importance.
Exactly right, because again, there are those two tracks, right? Even the defendants might have an interest in kind of covering this whole thing up, okay? Because Sydney and Jenna, and I know, right, it's easy to dunk on them, and you got to go to trial. How dare you take a guilty plea for something you didn't do? And I get all of that, okay? I get it. And I've represented many people who had that same opinion. And what ends up happening is oftentimes those people lose at trial. They go to jail. And it's, maybe a wise decision to attempt it, maybe not. Sometimes you do win. But in a politicized prosecution like this, where the kind of writing is on the wall, you take a plea deal sometimes if it's going to be a smoking plea deal that is not going to be a guilty conviction. Okay, so I know they temporarily entered a guilty plea proceeding and the court has held this whole thing in abeyance, but it's going to go away. So you can really justify that, right? The analogy is like defensive driving school or something. You just, okay, I did it. It's not worth the hassle. I'll take the deal. It'll all go away later. But what about the public? What about that second path here? We don't want these people covering this stuff up. We don't want the Fani to bury all of these proffers under the dark of night and then have them run around saying that Jenna Ellis and Sidney Powell have dished the goods on Trump when they haven't. We've got a whole election where that information would be very useful to show that, yeah, maybe they went through these proceedings, but it was on something that is not consequential, right? The implication is that Trump is guilty, and the proffer show, not really.
So, Your Honor, it's not a matter of whether both sides agree. It's a matter of whether the standard has been met, and we would submit the showing is clearly insufficient to meet that standard.
All right, and so they carry on and they go on for quite some time. The judge ultimately takes this whole thing under advisement and is going to issue an order at a later date and time. And so, my friends, of course, we will be here continuing to cover the RICO case. And as soon as the judge issues an order, we'll cover it. We'll see if they are going to be issuing a protective order that stops any more plea proffers from coming out. I'd like to see them personally. I think it'd be very useful to see if they actually have any evidence. I've long suspected that they do not. And we also know that in another video here, which I really recommend you watch, a federal judge out of Georgia, out of the Northern District of Georgia, called Amy Totenberg, said that there was monstrous election problems and deficiencies in Georgia, stemming all the way back to 2018. So with that juxtaposed with these weak proffers, juxtaposed with these weak plea deals, Fani has no case. Her case stinks. And so we'll be here continuing to cover this, my friends. I'd love it if you joined us as we do by hitting that subscribe button. Would very much appreciate a share of this content so that other people can see what's actually happening here and join us as we break it all down, because they are trying to create a narrative that just simply doesn't exist. Fani's case is garbage, and we're going to be here continuing to expose it. Thank you for joining us as we do. Thank you for checking out robertgovea.com to sign up for our daily newsletter, and we'll be looking forward to seeing you on the next one. All right, my friends. Whew, we covered some good ground today, man. Some big, juicy, meaty updates. We'll see what happens on the RICO case. Hunter sending subpoenas over to Trump. Major mistrial motion in the New York City case. That's going to be fun to see what Engoron does with that one. And hopefully somebody finds Alina. But now, my friends, it is time to hear from you. Of course, today we are going to go over to watchingthewatchers.locals.com for our members only after party. We do members only streams in the morning. We do Saturday streams, and we would love it if you joined us and connected with our community. We also are going to have an after party. So if you're on Locals, stick right where you are. Welcome to Star Redemption, who just joined us. And we'll be sticking around for the after party on Locals. Members on YouTube, go to the community tab section on YouTube, scroll down, 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 grab the Telegram link, and we'll see you on Telegram for the members only after party. But you can also, we'll see you on YouTube for the other stuff, the morning stream and the Saturday shows. But now, let's see who is in the house. And we got Donut Mind Me clipping for us today. And we're grateful for all the help from our amazing mods. And who is joining us on the day? Boom. We see, what the heck is going on over here? That was today. Hold on a minute. I think that was from this morning. So I was a little bit discombobulated. And now here we are from Donut Mind Me. He's helping me. He says, start right here. Start right here. Thank you, Donut. Hey, look who's here. Joe Maz over on the Rumbles says, first rounds on me, boys. First rounds on me, boys. Thank you, Joe Maz. Ravika says, hey, Rob, watching the Christopher Wray and Higgins conversation, it made me think of a question. When is the line crossed between obstruction of justice versus privileged information? That's a good question. I don't know. And I'm not sure what the context is around that conversation between Christopher Wray and Higgins, but certainly, right? It's privileged. You can't access this. It's legislatively privileged, executively privileged, whatever. But you're privileging evidence of a crime. What does that line look like? Good question. We got Suithar is over on the Rumbles and says, these work in the app now? Looks like they do, Suithar. You're in the app. Thank you for the dono, and thanks for testing it out on our channel. Bad Poet says, testing the dono for Rumble. Hey, we got a couple tests over there. Hate the U-boobs. Hate that they take the cut over on, from a Bad Poet over on the Rumbles. So is that true? We got a new feature on the Rumbles? Very, very cool. Thanks for testing it over here. 51K says, here he is, Alina's hubby. She's married. She's married. Okay. Her husband is not going to be happy about this. Not going to be happy about this at all. But it's a nice photo. First says, she's in Rob's apartment. I guarantee you she's absolutely not. I guarantee that one. Here's this one is from 1917 Beamer. Says, didn't Hunt's women call either Secret Service or FBI about, Hunty. Didn't Hunty's woman call either the Secret Service or the FBI about a gun and they fished it out of a dumpster? That was in 2018. And Joe was nobody at that time. Well, he was just a citizen. But he still had, he had all sorts of, Secret Service protection and FBI involvement. Yeah, but I think it was 2018. Good comment. Good to see you, 1917 Beamer in the house. We got Spud says, Rob, I hereby dub Judge Arthur the areola of anarchy. The areola of courtroom anarchy from Spuds over on the locals. Good to see you, Spuds. I like it. Has a nice ring to it. GDL says that should be a play called The Clerk's Puppet. The Clerk's Puppet. It sounds like a Netflix series or something. We got Dolphin Fan is the man bringing in new membos in the house. What's up, Dolphin? Good to see you. Guess who's coming in? Courtesy of Dolphin. Captain Flat-tastics here. Johnny Boy's coming in. We got Audie Joe. Lear is here and Karen A. All gifted membos courtesy of Dolphin Fan is the man. Grateful to have you here. And thank you, Dolphin, for bringing in new membos. Hopefully you're having a beautiful week, my friend. We got Fred Pedamonte. What's up, Fred? And his rascally dog, Johnny. Look at him right there. He says, Rob, problem? The judges decide recusals and mistrials. There has to be some type of judicial commission when a judge is so biased that they can't decide themselves. So there is actually. And Fred, you may remember, we talked about that one here, the Elise Stefanik complaint. So she filed a judicial complaint against Judge Engoron specifically. Now, what will they do with it, if anything? Maybe nothing. But they're also filing this motion for a mistrial so that they can also take that up on appeal as soon as the judge denies it. We got this one from Voice of the People is here, says, I did nothing wrong. We all know you're guilty before this case started. Motion denied. Quote from Arthur Areola Engoron. It's him. Yeah, I think that's factually true. I did nothing wrong. Okay. As he's, doing, we'll just leave that there. Good to see you, Voice. We all know you're guilty before this case started. Motion denied. That's exactly how the whole trial has been. And the Areola thing. A Bad Poet says, I can't wait for the day Engoron and Greenie the Genie get subpoenas for all their deleted tweets. Don't forget the unsent messages too. Yeah, well, when Trump comes into power, I guess he can use the DOJ to do all the same things they're doing. And we'll see how that goes. We'll see how they like it. Probably won't. Randall McCollum is over on the Rumbles. What's up? We got some good Rumbles in the house. Good to see you, Randall. Says, if it is inappropriate for a judge or police officer to, quote, troll or harass people because they are in a position of power, why is it okay for a YouTube mod in a chat to do it? Responsibility goes with authority. I agree. I don't think it's appropriate for mods to troll and abuse positions of power. And hopefully that's not happening. I don't think that it is. But Randall McCollum says you're right. Responsibility does go with authority. And so, Randall, it's nice to see you over on the Rumbles. It's nice to see you there. We got Fred Pedamonte says Scavino meant that they were never leaving the party. Oh, yeah. Jenna Ellis got it wrong. It's not like we're not leaving the White House. He's like, this party's off the hook, man. Have you had the dip? They got artichoke dip over there. Like somebody take it away from me. It's crazy. And Jenna Ellis is like, you have to leave. You have to leave the White House. He's like, I'm never leaving this White House. This artichoke dip, I will die for it. You'll have to pry it out of my cold, dead hands, Jenna. And she's like, oh my gosh, Liz Cheney, you're never going to listen to hear what Dan Scavino said. All right. Good comment, Fred. We got this one from Bruce. What's up, Bruce Rice? Bringing in 5 new members. Good to see you, Bruce. We got Angie W coming in. Big boy Blues coming in. What's up, big boy? We got David Macy coming, Perry R, and Grad and Dean. Grad and Dean is in the house, brought in by Bruce Rice, new members in the house. We got Knox Bierman says, how did a lawyer for a co-defendant get proffer tapes? This is a total lie. His client is not pled guilty, and these could have been agreements to testify against his client. Ooh, that's interesting. That's interesting, Knox. I don't know. I don't know how he got them. Yeah, maybe he just demanded them. He said, I need evidence about what you're going to testify to, and I want to see the proffer tapes. It's curious. I don't know how it unfolded, but he said so in court, so I'll take his word for it. And I think the thing, he's like, I didn't do anything wrong. I didn't do anything wrong. People need to know. And the judge didn't even care. The judge is like, okay, well, nice. Any other objections? Okay, see you later. It's good to see you, Knox. We got this one from Knox. Says, the state gave him these on purpose. Let's see what deal his client gets. It sounds like collusion. Ooh, Knox. Knox is a defense attorney, so it's very interesting to get your take on it. Let's see what his client gets. Well, she should get exactly the same deal that Sydney got. I mean, she's like lesser charges than Sydney. If she does not get a diversion deal, something's off, because Sydney got a diversion deal. And she was like less involved than Sydney. Great Grandma Anon became a supporter over on the YouTubes. Very nice to see you, Great Grandma Anon, in the house. Glad to have you. Welcome as a supporter. And we'll see you in the members only after party, but grab the Telegram link on the community tab section on YouTube. Rocky Water says, vocab tip, cheers to discombobulated. Love that word, discombobulated. Did I say that or did somebody else say that? It is a good word. I need to say it more. The Rubos say, Rob, thank you for yet another outstanding live stream. Keep up the great work. Thank you to the Rubos. And of course, we love the Rubos. You can get the Rubos salt at rubossaltshop.com. It's great salt. I don't know what you're using, but that's what I use. B. Torn says, where'd the corporate media go? They disappeared when Trump's defense started. Isn't it curious? You mean in Tishy's case? They're not all that interested in Tishy's case? And as soon as Trump, has some evidence, they're like, well, it might be good evidence. And so we don't want to talk about any of that. Of course, my friends, thank you for those very nice donos. Very much appreciated. I'm grateful for all of your support. Let's say what's up to our friends on the X platform before we go over to our members only after party. Oh, John McGarvey dropped this. What's up, John? Look at this. Ooh, has this one for us. Hey, watching the watchers. Hey, man, that's what it feels like to be swolled up here. Man, I'm not that big. I got to work on my traps a little bit to get that size. But yeah, check out the sponsor of today's episode, twc.health/Robert. And John, thank you for this. I love it. It's beautiful. Looking good. It makes me, I got to girth up a little bit, don't I? Got to get some more girth. Fred Pedamonte is here. Says, Rob, I just ordered a time machine so I can continue to watch the show at 6 p.m. Eastern time. Well, let me know how that works, because I might need to use that. We could use that for some other things. We got Raven Madness is sharing the subpoena story. We've got Tin Man says, great show. Drunken Senpai saying 32. M Money says, thanks, Rob. We got George is here. We got That D Guy says, if the court denies Trump's motion for a mistrial, can he appeal it? I would say yes, he can. Yes, he can, because, well, I don't know in New York what the specific rules are, but I would say yes, he can. There's collateral consequences to all this. It's not remediable. Like at the conclusion of the trial, we'll see. Now, Sharon the Patriot says, can we go to a higher court? I think the answer is yes. And I'm sure Trump will, just like what he did with the statute of limitations thing. And so we'll see that all come down the pike. But that, my friends, that is what we saw over on the X platform. Thank you for joining us on the X platform. And we're grateful for you following us there. We are going to wrap it up and head on over to watchingthewatchers.locals.com. We had Flash River, who's on Locals, sent this one in. It says, Rob, I'm curious if it's possible for Trump to settle out of court per Engoron's and Tish's clown court. It would probably cost less to settle this case than to go to trial. Your thoughts, pros and cons? Well, cons would be Trump settles a case and he has to accept some civil liability, which he hates to lose. So that's a con. Pros would be maybe he settles it for a lot less money. So they want, I think now about $250 million. So maybe he settles it for much less. Con would be Tish would declare victory with a settlement. Pro would be Trump would pay a lot less in terms of time and efforts. So, a settlement's not necessarily a bad thing. I think that Trump could claim victory by saying they wanted $250 million and he didn't get it. But then if Trump settled it, I think he might lose some of the appeal arguments, right? Because it's a settlement. So he would forego any of those appellate claims. And I kind of want to see him to push the appellate claims through, in particular the gag order. And I think he should invalidate the whole trial, honestly. But he might not want to do a retrial, right? Now weigh that against a retrial. Does he want to come back and do a retrial, or does he just want to settle this now? Like settle it now or win on appeal and then get a different judge and come back and do the trial again? Or do you just settle it for, $10 million? I don't know. Good comment, Flash. We'll have to see what happens. But my friends, that is it for us on the day. We are going to wrap it up and head on over to watchingthewatchers.locals.com for our members only after party. We'd love to see you there. We got members only streams in the morning. We got Saturday shows and a great community. So come say hello. We also have our website, robertgovea.com, where you can get all the daily show reports over there. Sign up for our daily newsletter. Click that blue button. Sign up. You'll get these reports delivered right to your inbox. The PDFs are on here if you want to dive into the red lines that we talk about. And each video is translated into a show report. So you can just read what's going on if you don't want to watch the full video. Again, all the court documents are there at robertgovea.com. That is the web address. So we're heading there for our after party. Shout out to our mods and meme smiths who mod the fort down for us. Our friends, Vientikis Prime, K Bean in the house, Just Cause, we got Playin' Hooky, Ronnie Cole, our friend Zulu, Beyond Geo, Zach Nichols, John Allen, Janek 909, Dog Digger, and of course, Donut Mind Me with Zach and John and Donut clipping away for us on the day. We also got our meme smiths, Geegum, Geegum over on the locals, Nathan N810, and of course, Sleepy Dog Lee on the X. That, my friends, is it for us on the day. We covered a lot, but it's only Wednesday. We got a full week ahead, my friends, and so we will be back here tomorrow to get into it all again. And we need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.